May I, Lordship, mention
Yes.
appeals for hearing, FMAT.
Appeals for hearing. FMAT Group 8.
No, my Lord, FMAT, my Lord, the second
Second
first
appeal.
is just appeal.
Second appeal, yes.
And one is application.
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 Application in connection with second appeal.
Appeal.
Substitution application.
Yes.
Okay. Application would be appear on 6th of December under the heading application, and the appeals would be appear in the list on 13th.
30th. Grateful.
13th of December.
Hearing বললাম তো জজকে হ্যাঁ একটা অ্যাপ্লিকেশন আর হিয়ারিং দিয়েছি
Upon notice, my lord, may I be permitted to mention, my lord, one application.
Just wait. কি হয়েছে?
That those are the hearing.
Permitted to mention one application in connection to second appeal and another second appeal for hearing, my lord.
6th and 13th.
My lord.
My lord, may I permitted to?
My lord, I have served the notice to the respondent, my lord. The Honorable Justice passed the order, my lord, fixed for hearing further hearing, my lord, cases. My lord, I am paying before, my lord, fix the matter 17th December 2000.
How?
How, my lord, this matter is fixed for hearing of the.
Further hearing means there must have a hearing.
Yes, my lord.
They go before the bench.
My lord,
I can release the matter.
my lord, termination change, my lord. This course-
I understand, as the matter has been heard substantially, you can approach the Chief Justice that the matter can be heard again by the bench who has started the hearing.
It's not possible, my lord, because my lord, that matter, my lord, determination in this case. That is the difficulty.
Then again, you have to start before me first from initiation. That is the difficulty for your client.
My lord, my
Nothing.
client is here citizen, my lord.
Then that's why I am asking before the Chief Justice so that the matter can be started again before the bench. Where you started the argument, wherever may be the particular bench, it may be assigned if you wish. Otherwise, I have to fix my regular dates. I cannot fix 17th.
13 December, it is possible to fix the matter now.
I can fix the matter, but there are some old matters which are already fixed on 13th. That has to be taken first.
My lord, 17th December. My lord,
No. 17th December cannot be taken. 17th December, I have some other determinations.
any other date, my lord.
I can list it on 13th. I cannot guarantee your hearing. That's the only reason. I am just first. I am listing the matters. Thereafter, after slotting, I will take the matters one after another.
For senior citizen, my lord.
That's why I am asking you go before the Chief Justice. Let it be released.
December, fix the matter.
Let it be released.
So this, then okay.
How many matters are there? Just wait, Mr. Hotel. How many matters? One matter.
One.
Okay. 13th.
23 and 70 of today's increment is going to be extra on 29. 23 and 70 of today's. So for 23, this is appearing under the heading excess of interim order.
It will be taken up today.
It's not been taken up. Then 23 and 70.
17.
70.
70.
Yes.
What do you want? 70.
It's going to be extra on 29 in these two matters.
Okay. If I take the matter 23, then I will pass the order on 70. Okay.
Regarding item number 62 of today's list,
62.
Abhijit Kormo, the interim order was there till today, and you'll also pleased to fix the matter today, but that may not be taken up today. Item 62.
Item number 62.
You will also kindly allow me. I can serve notice to the other side and came back at 2 p.m. for only the purpose of extension.
2 p.m. I have some other determinations.
No, also for purpose of extension of interim order. I shall serve notice to the other side. I will inform him. Only for the purpose of extension and fixed any date, subsequent date.
Then you come on tomorrow then.
Tomorrow to dimension extension as well also. Item 60.
For the order lagbe na to. Okay. Tomorrow to mention.
I shall submit it to the other side.
My lord, may I permitted to mention one second appeal matter? I have served the notice to other side, my lord. It is
Hearing.
hearing matter, my lord.
13th.
Milord, may I be permitted to mention one second appeal hearing matter, madam? I have served notice to the other side, madam.
Only old matters should be taken up first.
Hold matter, madam.
I have matters of 65, 70 like that. I have started only 2 matters for hearing of old matters.
Madam.
Okay. List it first.
Milord, may I be permitted to mention, Milord, four writ petitions of 1980s, Milord, 81, 82, 83, and 84. These were 4 writ petitions which your lordship was hearing, and your lordship had marked it as part heard, Milord. Mr. Moinak Bose, learned senior advocate, is leading me in that matter. Milord, there was a direction for reconstruction of records of 2 of the 4 writ petitions. The reconstruction has taken place, Milord. If any day could be given, Milord, for
Reconstruction of group 2 matters.
Group 8, Milord. These
Group
are
eight
Group 8 matters. 4 writ petition, analogous point, Milord. Your lordship was hearing 2 matters.
Whether reconstruction has been made.
Yes, Milord. All the 4 are ready, Milord. Any day, if your lordship can.
I will list the matter. No issue.
My lord, may I permit you to mention one matter, my lord? On the last occasion, 21st
Deeply.
August 2024, your lordship has given direction upon the respondent authorities to file an affidavit in opposition within 4 weeks. Till now, no affidavit and opposition has received us. Liberty to mention before your lordship, it has been directed as your lordship after the stipulated time. So for inclusion, my lord.
Do we mention?
My lord, I'm mentioning upon notice, my lord. I'm praying for, my lord, inclusion of application in connection with the, my lord, second appeal, my lord.
6th of December.
Grateful.
Under the heading application.
Grateful, my lord.
Permitted to mention one application for compromise in connection with the second application.
6th of December.
Lordship, may I permit to mention, your lordship, extension of interim order, your lordship.
May I permit
To be mentioned.
one second appeal matter ready for hearing, paper is ready, madam.
Okay, 13th of December.
My lord, mentioning a very old.
Oh, very old matter.
My lord, hearing stay.
Second appeal.
1970.
You are appearing
For the appellant.
for the appellant. 76,
77, 1970.
77 appeal.
Hearing
6th
stay.
of December.
Item number 52. I made the matter yesterday, and I forget to keep the number, my lord. It appeared to me as an on my port. Instead of Mr. Sada mentioned at 2 p.m. I forget my keep the number. Item number 56.
56. Yes, 56 is there under the heading of new motion. It is what you want.
It appeared and to be on 4th December. Subject to convenience.
4th December. Next Wednesday. Next Wednesday. It would taken up in the list. Let it be called. Otherwise, it would be appear. So you want to fix the matter on 4th. 4th করবে 56 mark করে দেবেন ডায়েরিতে 4th of December.
My lord, one innocuous way, my lord. Item number 1, my lord, which is fixed at, my lord, 2 p.m.
Yes.
My lord, in this matter, my lord, my lord, kindly recall that it pertains to, my lord, that employee of, my lord, who is a contractual employee of my lord, college, and Mr. Bilodal Bhattacharya is appearing for that, my lord, college.
Yes.
My lord, last Wednesday it was fixed, my lord, but my lord's bench was indisposed. My lord, this day, my lord, Mr. Bhattacharya has some, my lord, personal difficulty, my lord. May it be adjourned, my lord? I am indicating
one argument on behalf of petitioner has concluded.
almost. He said almost concluded.
Mr. Bhattacharya.
Mr. Bhattacharya was to
supposed
reply.
today.
Yes, my lord. May it be, my lord, taken up next week, my lord. He
Let it the petitioner. Why is the petitioner? Petitioner.
then, my lord, when the matter will be called
Yes,
on.
I'll pass the order to PM.
Grateful, my lord.
Call the matter.
Lordship, in this matter, I am appearing on behalf of the state respondents, Lordship. Lordship, Lordship, I'm ready with the matter, but if Lordship can kindly keep it at 2 p.m., it will be.
Today 2 p.m. I have some other determination. Today 2 p.m. I have some other determination. Group 2 matters, pattern matters are there. That is the difficulty.
Any other day then, Lordship.
What is the matter? This is the Rajesh sake. Okay, I understand. So you are to argue today.
Yes, because today if it starts, then it will continue for some time and upon some difficulty because
they have the difficulties, I can start and only 15 to 20 minutes, very short matter. Then they will go.
No, today or another day, so it would be better to start another day. Monday, Tuesday. Tuesday. Third. You have difficulty in third. Fourth. Okay, come on fourth. First matter.
was
Fourth, first.
Fourth,
grateful, Lordship, grateful,
10:30.
10:30.
grateful,
Fourth, 10:30.
grateful, Lordship.
My lord, I'm appealing for the petitioner, your lordship, this is the matter for correction. Your lordship has passed this order, only second paragraph of my lord's order, where it was written, the petition expired during the pendency of the writ petition. That is to be deleted. Other portions are okay, your lordship. The operative portion is also fine, your lordship. There is no dispute in that. Only the second paragraph. The petitioner died during the pendency of the writ petition. That second paragraph of my lordship.
During the pendency of the writ petition, the said retired employee of the corporation expired, and in his place, present petitioner are
Lordship.
substituted.
Lordship, this paragraph is to be deleted because the petition is still alive.
Okay.
Only this paragraph, this three.
Only this paragraph.
Only this. Operative portion is okay, your lordship.
This matter appears for correction. In order dated 12/9/2024, at page 1, the second paragraph, starting from during substituted, should be deleted. Remaining portion of the order should be unaltered.
Lordship. Lordship, grateful.
Next.
This is a non-prosecution and it does not want to prosecute the writ petition. I'm giving the instruction. The instruction.
What is your name? Please take down. Mr. Shubhankar Das, Learned Counsel, appearing on behalf of the petitioner, submits that petitioner doesn't want to proceed with this matter further. Mr. Das has handed over a written instruction from the petitioner. Let the written instruction be taken on record. Full stop. Next, we're having heard the Learned Counsel, having heard Mr. Das, as well as the written instruction of the petitioner, the instant writ petition be dismissed as not placed. Interim order, if any, passed by this court during the pendency of this writ petition be also vacated. This poster. Next.
By instance, this matter has been happening. I have filed an application. Chatterjee is appearing on behalf of the respondent.
Where is he?
Last annexure is the order which basically the order was passed. The disposal of the appeal pending Honorable Division decided by the Honorable Chief Justice.
Yes.
That matter has been disposed of.
Hmm. Hmm.
But this is the impact song. But what happened, my lord, after the after disposal of that matter, are being taken to issue the license. What I am saying for your lordship in terms of the order of the honorable division and subsequently passed. For the order which I am praying for your lordship is at, it starts from page 12. Operative part is at 15.
That is the order of division bench.
Division bench order. And so far, the order passed in the repetition of your petition of the petition is that it is at page 10.
Yes.
Till dismissal of the mandamus appeal. It's dated 25th September 2023. Subsequently, bunch of appeal has been filed, my lord.
Now, what is the present status of the appeals?
Status, my lord. Probably they have issued the appointment letter in favor of the private, in favor of the selected. That's why I'm praying on not to delay and not to make any allotment also.
Now, what is the status of before division bench?
Division is pending, my lord. Interim order is being
Extended.
till
Extended.
30th and subsequently been extended.
So regarding this matter is concerned, what is the latest position, Lordship? I have no instruction. Actually,
He is
for my
saying that the
understanding,
license has already been issued.
No, license has not been issued. I've stated paragraph 12 also.
You are saying license?
Appointment letter has been issued, not
Okay.
the license.
no license.
Appointment letter has already been issued,
Was
not the license.
not the license. That's why I'm saying, my lord.
This is a very old matter, Lordship. I have no instruction at
I
all.
understand.
If my lord, the Lordship, if Lordship was identical issues or my lord was held and
Yes,
Lordship
I have dealt with all the matters.
Yes,
There's no
yes.
issue.
My lord may pass an order in terms of the division bench order, not to delay. That would be good. Not to delay and not to make any allotment. That's the order of the division bench.
Yes.
They are paying that order. And your lordship passed the identical orders in other matters also. It starts from page
19.
Oh, that has been not uploaded. Yesterday, your lordship has passed another.
No, 19, page 19 of the application is an order passed by this court.
Subsequently, my lord, in terms of the division bench order, your lordship passed some order. Yesterday also, your lordship.
Yes.
that was modified, my lord.
Yes, not uploaded. Your lordship may pass the order directing them not to
Yes.
retract the cards and not to make any allotment.
Or my lord, if the Lordship's desire was the compliance with the division bench order.
Yes,
Division
that's
bench
the
order.
difference. Page 15. Page 15 is the operative portion.
There is. Please take down. Can 1 of 2024. This is an application for an interim order in respect of stay of vacancy notification dated 24th February 2023. Issued by Subdivisional Controller, Food and Supply, Dakshin Gangarampur, Dakshin Dinajpur. Full stop. For the full stop corona. For location Belbadi,
Page 29 of the writ petition.
Yes, Bel, Belbari, within bracket, ward number 3, near Kadihat, Belbari High School. Mr. Pingal Bhattacharya, learned counsel, appearing on behalf of the petitioner, submits that initially at the time of filing of the instant writ petition, this court has passed an interim order till the disposal of an appeal pending before the division bench presided over by Honorable the Chief Justice. He submits that the appeal before the division bench has already been disposed of. Mr. Bhattacharya further argued that the similar issues are involved in a batch of writ petitions before the division bench, being MAT number 1543/2024. Full stop. The Honorable Division Bench has already passed an interim order in the appeal. Submits that the instant matter cannot be disposed of till the disposal of the appeal. So he prayed for necessary interim order. Learned counsel Mr. Amritalal Chatterjee, appearing on behalf of the respondent authority, submits that this is a very old matter. The issues involved in the instant writ petition is not similar to that of the issues pending before the Honorable Division Bench in the appeal or the learned counsels. The present petitioner, next one, the present petitioner challenged impugned vacancy notification for appointment of FPS dealer over the operational area, where the present petitioner is already running FPS shop dealership business with an unblemished track record and full satisfaction since long. The petitioner has challenged the vacancy notification on the ground that after promulgation of National Food Security Act 2013 and targeted public distribution within bracket control bracket close order 2015, the control order of 2013, on the basis of which the vacancy has been declared has become redundant.
না আছে অনেক একই অর্ডার
I am aware of the fact that the same issues are involved in the batch of appeals pending before the learned division bench in 1543 of 2024. The Honorable Division Bench in the appeals has passed an interim order directed the state authority not to delink the ration card holders from any dealers, as well as the dealers may not be dealing from distributors till the disposal till further order, until further order. Full stop. Next para, this being the situation, it appears to me that if the authority concerned proceeded to issue license in favor of a third party, multiplicity of the proceeding would be cropped up. Cropped up. As well, the order of Honorable Division Bench would be violated. Full stop. To maintain the judicial sanctity, it would be appropriate to pass an interim order in terms of the order passed by the Division Bench. in MAT 1543 of 2024. 1543 of 2024. Under the above observation, the instant application being Can 1 of 2024 is disposed of. State authority is hereby directed follow the direction of the Honorable Division Bench passed in 1543 of 2024 in respect of the impugned notification, vacancy notification, till the until the further order. Full stop. Can 1 of 2024 is disposed of. Let the matter go out of the list. Parties are at liberty to mention.
Only intelligence I'm playing today. May I get the server copy today?
Today,
If
today second half is there. Thereafter second half.
I'll get
Very.
Yeah.
My learned friend,
Great for my lord.
we shall communicate the order and they will act upon such communication. But can make a report that's it.
Depend.
বলে দেবে।
এটা আজকে কোর্টে তুলে দিয়ে যেহেতু ঠিক আছে হয়ে যাবে সেখানে পাঠিয়ে তুলে দেবে। ঠিক আছে ওকে আই উইল
I'm grateful. Much.
Maybe your lordship, my lord.
Yes.
For this matter, I prayed for restoration of my dealership on the last occasion.
There was a direction to
Yes,
file
sir.
affidavit.
And because of the fact that there was a criminal case against me, which was disposed of in the year 2024. Then I made a representation and I prayed for consideration of that representation. At this juncture, my learned friend made certain arguments from the bar that there are certain litigations pending, there are certain more orders. Then your lordship was pleased to direct them to file the affidavit, but they have not filed any affidavit. Therefore, my lord, what I am praying for, let them whatever they want to say, consider my representation, and while considering representation, they can make whatever they want to say, so that I can come before this court again.
My lord, since our litigation is already in existence before your lordship, and your lordship has been pleased to direct us to file our reports, my lord, the cases, my lord, which are involved here are more than 25 years old. We have applied for certified copies. We'll bring everything before your lordship. So this will cut short the another litigation. Everything will be decided before your lordship only.
So if the litigation is not,
My lord, my lord, grant us 2 more weeks, my lord. We'll file our affidavits, my lord. My lord, because we have applied for certified copy, we are constantly, my lord, pursuing this matter.
in any case, my lord, they can say it is while considering
My
my
lord, without
representation also. Your
records, we
lordship may
cannot
grant
consider
it
any representation.
while they may make.
Thereafter, that reason order will be susceptible to challenge before your lordship.
Yes,
Then
yes.
again, the same thing will be repeated.
Even if he
So, my
gives
lord,
the
kindly
order
grant
here,
us 2 more weeks extension. My lord, we'll file our affidavit. We'll
my
get
lord,
it.
client is my lord suffering and they want to give this time.
My lord, this is a person who is.
This is not correct, my lord. They are making submission.
My lord,
from
this
the bar.
dealership was terminated in 1998. Now in
What I am praying
2024, he is suffering.
So I am praying
My
for
lord, there are other
restoration,
cases
but
as well.
What is my innocuous prayer? Let them consider my representation. Minimum permission. Let them pass order.
Your
Let them say
documents.
that there are several litigations.
Oh,
So-
where is your representation?
My lord, that is at page 24.
That is the only prayer.
That is the only prayer, my lord.
Let them say in the order.
22nd July, this representation was made. They have not considered it. They could have said so.
Whatever we'll say, my lord, in our reasoned order, my lord, we can say it in the affidavit before your lordship.
No,
My lord, this will cut down the another litigation.
No,
My lord, this will cut short another litigation. Everything will be decided before this court only. Since my
litigation
lord,
cannot be
your
curtailed
lordship
by
was.
my learned friend. Even if they give the reply, affidavit, I have the every right to give the
No,
reply. And
if the litigation is pending in respect of the
No, there is a 99 case as well.
My
EC
lord,
case
that is submission
99.
from the bar, no
My lord,
document.
we have submitted the division bench's order, which has been suppressed by the petitioner. It does not lie in the mouth of the petitioner to say all this. This litigation, this division bench's order, which the petitioner
Then why
suffered.
is not- When he is in the position of the.
My lord, we are in the
order,
position of a
but he
division
is not
bench's
getting
order,
the
but my lord, we cannot file an
Why
half-backed
he is
affidavit.
He is asking for affidavit that he is to get certified.
My lord, that division bench's order speaks about an EC case.
This is not fair on the part of the state advocate.
EC case is pending.
My lord, a 99 EC case was there.
EC case
My
is
lord,
reputed. Your lordship will kindly come to.
My lord,
page
a
22.
division bench's
One
order was
EC case is, order has been
my lord,
passed.
three EC cases were there. One of 1990, one of 1992, one of 1999.
Page
The
23,
1992 EC case, my lord, was disposed. Acquittal happened in 2023, sometime in 2023.
Oh, my lord.
So, my lord, the EC case 1999, that fate is not known. He has not brought that EC case before your lordship. He has
Even if I have
suppressed that.
suppressed something, my lord.
Even
Okay,
it is
let
pending.
let him make submission, then my lord, I shall make.
No, even it is pending. You can demonstrate the matter. You just to give me the number. That will
Lord,
be sufficient.
My
No,
lord,
my lord,
that,
your lordship
my lord,
can-
whether that EC case is currently pending before the trial court or not, because my lord, the honorable division bench of this court in 2001 held that he is not eligible for dealership, his termination was valid. He has not preferred any appeal before honorable Supreme Court from that order. So, my lord, the fate of his termination was decided by the division bench order. But, my lord, please. But, my lord, since we are to come before your lordship with an affidavit, my lord, we want that all the facts, even the pendency of that EC case as well, will be brought before your lordship. My lord, for that only, we have applied for certified copy. There were vacations of trial court as well. You know, there is a delay. Well, we'll file it. We are constantly pursuing that matter.
From
You know,
7th
kindly
October,
grant us 2 weeks time.
it is 1.5 months.
It will only save time for the petitioner as well. And my lord, I'm not in advisory capacity, but my lord, since your lordship has already given us time to file our affidavits, my lord, kindly grant us 2 weeks time. My lord, we'll file our affidavits. Then your lordship can decide.
No, my lord, he has made submission. Please do not interfere when I make submission. Your lordship kindly come to page 23. This EC case has been acquitted. This was of 1992.
Yes.
And that the accused person, namely Sajan, is found not guilty. At page 23, my lord.
23.
Yes. Immediately thereafter, my lord, I
Case
made
number 17 of 1992.
Yes. In 24, it was disposed of by holding that I am not guilty. Then, my lord, I have made a representation for restoration of my dealership. My lord, if there is any other case, then they can disclose it in the regional order that I am not entitled to get. But merely by making submission from the bar that this is pending, that is pending. My lord, your lordship they cannot ask for withholding the order for consideration of representation. What is the problem with the authority for consideration of the representation? Even if I make a wrong representation, that should be responded by the authority.
Yes.
The authority will file an affidavit before your lordship only.
No scope. If I have
Lord,
paid for
order has
restoration,
been passed, so there is
then
a scope.
When I am
तो
paying,
बोले दिले sir.
let me make.
बोलून sir.
When I am, my lord, I am only paying for. I am not paying for restoration. Though I have made prayer for restoration, if your lordship passes any order for restoration, then definitely that cannot be done without asking for a prayer. Even if your lordship has given them time, it is 1.5 months. They have not filed a affidavit on the plea that they have not got the certified copy. If there is any order in their hand, they do not need any certified copy. They could have brought in to the notice of your lordship by way of affidavit. That is not done. So let them pass. Let there be a direction upon the authority to consider representation by giving opportunity of hearing, and let them reject my representation by holding whatever is there. There cannot be any issue for this. Even if there is anything in the affidavit, whatever.
Okay. Okay, hard.
My lord, order of this court has already been placed before your lordship, the division bench's order. My lord, that order records that the dealership was terminated pursuant to an EC case number 99. My lord, we have submitted the order.
Something is made.
We have submitted the order. How can?
Okay, hard. There is no chance.
অর্ডারটা কোথায়? বাস ঠিক আছে।
Enough was placed in the representation even, my lord. Last paragraph, request to give an opportunity of hearing to my client or his authorized representative for considering the representation. That's what I am praying for.
when your license was terminated in the year 1989,
1992.
1998, my lord, sometime in 1998.
1998.
It was not pursuant to 1992 case. 1998, he supplied. His license was terminated in 1999. But I have orders.
From instructions or without record from the bar, no document. Let them record it in the order.
My lord,
That is
allow
what-
us to file an affidavit, my lord. We'll demonstrate everything to your lordship. We have already placed the division bench's order on the last occasion when your lordship was pleased to direct us to file affidavits, my lord.
They repeat it.
On 19th of September 2002, the division bench allowed the FIR to pursue, and the termination of dealership, my lord, was held valid.
Okay, heard. Please take down. Petitioner. Was an MR distributor whose license was terminated in pursuance to a criminal case being AC case number 17 of 92. It is the case of the petitioner that the said criminal case being EC case number 17 of 92 started under section 7(1) within bracket A within bracket 2 of Essential Commodities Act was disposed of by the competent special court wherein the petitioner was acquitted. He submits that after such acquittal, the petitioner has submitted an representation before the concerned authority
Page 24, my lord.
to restore the MR distributorship of the petitioner. The representation of the petitioner was not considered. Hence, this writ, Mr. Ganguly, learned counsel appearing on behalf of the respondent, submits that there is a specific observation of Honorable Division Bench of this court in WPA number 2462 of 2000, dated 19/9/2002. They further argued that the litigations against the present petitioners are protracting. Some of them are protracting, and some of them are still pending. It submits that this court has allowed the respondent state authority to file the affidavit in opposition. Such opposition is not ready, so he prayed for some more time to demonstrate the matter before this court. Mr. Agarwal, learned counsel for the petitioner, has submits that the authority concerned may be directed to consider the representation of the petitioner, and they are liberty by law to dispose of or reject the representation. Mr. Agarwal further submits that the submission on behalf of the respondent authority without any specific affidavit cannot be considered at this stage. Having heard the submissions of the parties, it appears to me that this court has given an opportunity to the state authority to submit an affidavit in opposition, though the order was passed more than 1 month ago, but it would be appropriate to give a 2 days opportunity.
My lord, we'll file it.
To file the affidavit in opposition within this week. Let the matter appear in the list on 2nd of December under the same heading.
As your lordship, my lord, instead of WPA 2462, my lord, it kindly, my lord, correct it with MAT 2462, my lord. Since it was an order of division.
MAT 2462. Sorry. MAT 2462 है प्रथमটা WPA লিখেছি না Monday.
As your lordship pleases me. Division means the final product.
But it will appear under same heading, my lord.
Yes, same heading.
এই সমুদ্রের মামলা জানি না কি করে পাবো
My lord, 17, I am for the petitioner, my lord. The petitioner is a widow daughter-in-law of a diseased MR dealer. She belongs to SC category. My lord, the MR dealer, when he was alive in his lifetime, he applied to transfer his license to his elder grandson because his son has already died before 8 years ago. Then, as his elder grandson was minor then, and my license was not transferred to minor, so he wrote one letter to transfer his license to his daughter-in-law. But it was not submitted because he was very ill then, and within 1 month he has died. After his death, my lord, his daughter-in-law has applied, and her application was forwarded by DC to Deputy Director License DDPS, resubmitted on 3rd September 21 along with 61 original documents. But it was
where is the application? Age?
My lord, application is 73, my lord. 73 application, 74 from C.
73.
73 her application.
Yes.
And 74 from C.
Okay.
And my lord, kindly see page 91.
Yes.
My lord, page 91.
Yes.
That district collector Uttar Dinajpur, controller Uttar Dinajpur is resubmitting case record of Srimati Chintamani Sarkar as FPS dealer on compassionate ground. Enclose concerned original file containing page 1 to 61. But it was not disposed of till today. In the meantime, on May 15, 2024, they have issued one vacancy notification mentioning her area along with two other area. It is in 92 notification, page number.
What is the area of Brajomohan Sarkar?
Dhamdol, my lord. Dhamdol. It was mentioned in their license, last license, 23A. Case 23A. Dhamdol.
Dhamdol.
Yes, my lord.
Dhamdol. So what is your prayer now?
Now prayer is, my lord, let they first dispose of the application of the petitioner as her appointment as compassionate ground, and they can recruit new dealer for the rest two area, leaving her area. New service area is Dhamdol, Gunarajpur and Sibrampur. So Gunarajpur, Sibrampur, they can recruit new MR dealer. There is no objection. And let the Dhamdol for the petitioner.
Yes.
But we are yet to receive instruction, my lord, in this matter. My lord, as it appears from, my lord, the application, the death of the dealer happened on 29th of April 2020, and the application was made on 29th of May 2020. My lord, as per the control order, the inclusion of widow of predeceased son within the definition of family member was done, my lord, sometime in December 2020, 16th of December 2020. So on the date of death, my lord, the provision for widow of predeceased son to be included as a family member and to be given as a compassionate appointment was, my lord, as it appears to me, it was not there. My lord, still, my lord, we'll be able to submit more, my lord, when we receive detailed instruction in the matter, and why the matter is been pending for last 4 years, my lord, we'll apprise your lordship.
My lord, as there is no one in the family of disease MR dealer, his only son died before him.
I understand.
So,
but if it can be taken up tomorrow, my lord, we'll come with instruction, my lord, on this matter.
Tomorrow, Thursday. Okay. Thursday is the day. Okay. It can be heard on Monday.
My lord, as your lordship pleases, my lord, will apprise your lordship with detailed instruction.
Otherwise, you file affidavit, I will stay the other process of the notification.
My lord, first, my lord, let us, my lord, apprise your lordship, my lord, about the facts of the case, my lord. We are without instructions today, my lord. On 21st of 11th, November, my lord, it was served upon us.
My lord, the process has started in May. So in the meantime, if they recruited new MR dealer, then where the petitioner will go? He has nothing. Two minor daughter, son and mother, 40 years, widow. She has nothing.
Okay, come on tomorrow then.
My lord, I will come tomorrow.
Come on tomorrow. First
Okay, my
matter.
Tomorrow same time, my lord.
10:30, first matter.
My lord.
Next.
In this matter, I am for the state. I am led by Mr. Swapn Kumar Dattur. He is appearing.
But I'm on the virtual mode, my lord.
Yes.
I'm a bit unwell today.
Very well. We are all unwell. No issue.
I am for the petition. But this is a case, 3 dates are very important. Your Lordship knows. My Lord.
Now, my Lord, before my learned friend proceeds with the matter, if I may assist your Lordship,
Yes.
he has made some statements in the averments and also in the grounds. The penalty amount has been alleged to be 7 lakhs, but the so-called notice shows it is 22 lakhs.
Well, I'm filing a supplementary amount, absolutely that I am handing over the supplementary evidence.
No, my Lord, that supplementary affidavit, I think cannot improve. This is a statement on oath by the petitioner.
Amount has been, instead of 22 lakhs, it has been stated well at 7 lakhs.
This is a possible result of my Lord card paste. I think.
If that's of the case is that, my Lord, what dates are very.
But let him first correct it, otherwise how can he proceed?
Handed over. I have already handed over to your London Junior the copy of the supplementary evidence. I have also filed before the court.
So the fine amount is for 23 lakhs,
Yes.
not 7 lakhs.
Not.
Yes. And everywhere in the grounds, in the averments, it is 7 lakhs. And the averments have been verified as true to knowledge of the petitioner.
I understand.
So, can the supplementary affidavit subject to corrections? I don't think by filing a supplementary affidavit, this can be corrected. This requires amendment.
Okay.
It requires amendment of the writ petition.
That should be done. Well, what dates I am just giving, my Lord. Your Lordship knows, my Lord, 2024 new control order came into force from 1st August 2024. Can you take note of these dates? 1st August 2024, West Bengal Public Distribution System Maintenance and Control Order 2024 came into force. By repealing the previous control order with relaxation that if anything done.
1st
August 2024. Repealing the previous 2013 control order with the saving clause that if anything done, already done, any proceedings initiated, then that should be continued. I'm handing over a copy of the control order.
2024 control order.
It came into force 1st August. I'm handing over the copy, my Lord. First page, Your Lordship. Second page, kindly see the date. And Your Lordship, kindly turn up to the saving clause at page last but one page of the control order. That is position. Well, kindly turn to page 35, 34 of the control order. Last portion, repeal and saving. Page 34 of the control order. Top left hand side, the pagination has been given.
Yes.
Clause 68, repeal and saving. The West Bengal Public Distribution System Maintenance and Control Order 2030 and the West Bengal Urban Public Distribution System Maintenance and Control Order 30. Well, pausing for a moment. Your Lordship knows initially there was 2 control orders, one meant for rural area, another for urban area. Now, my Lord, both the control order has been merged, repealed, and a single control order has been issued. Then kindly turn the next page. Notwithstanding anything such repeal, anything done or any action taken, is important. The causes already initiated against the cases already initiated against the licensee. If the procedure for filing of the so anything done, that is the saving clause. Any proceedings initiated by way of issuing show-cause notice prior to coming into force, that will continue under the previous control.
Yes.
But now, Your Lordship, kindly take the next date on 7th August 2024. I had no knowledge. An inquiry has been conducted by them. According to them, an inquiry has been conducted to the doorstep of the consumers on 7th August 2024.
Yes.
Number 14th August 2024, a show-cause notice has been issued. 23rd of August 2024.
23rd August.
My Lord, kindly turn to page 22. 14th August 2024. Show-cause notice.
Page
22. Annexure P2. Right hand side top, kindly see the date. Date 14th August 2021. Date of inspection 7th August, which I have already submitted before. Date of inspection.
Yes.
7th August. Date of issuance of the show cause 14th August. Have you lordship got my lord? I have already submitted.
14th August.
14th August is the date of issuance of the show cause notice.
Show
And the
cause.
date of inspection. Next line, date of inspection, 7th August.
7th August.
Fine. Now, your lordship, kindly take the show cause notice, the contents of the letter. This is to inform you that the inspection under reference, my lord, that is means, my lord, 7th August inspection. The following irregularities have been found. The dealer was found making only authenticated transactions through e-post machine, but not making delivery of food grains in the beneficiaries in the so and so under para 19.12 of the control order. Next, during the time of inspection, your lordship may not go through the entire paragraph, just last paragraph. It prima facie appears that you have contravened the condition stipulated in para so and so of the control order 2013. Non-existence, non-est law, invoking the provision of a non-est law, this show cause notice has been issued. So far, supply of inquiry report, supply of complaint, I am not taking any point today. 1st August 2013, it has been repealed, no existence. 7th August inquiry and 14th August show cause notice under a repealing act. I am not taking any other point today. I have stated in my writ petition, no inquiry report has been given, total violation of principle of natural justice. Then, my lord, kindly turn to page 23. Notice for personal hearing. First paragraph. Last line, under the provisions of West Bengal Public Distribution System Control Order 2013. Have you lordship got my lord? First paragraph.
Yes.
Process has been quoted of 2013 control order. I have been asked to appear before that. Then kindly turn the page 24. This is the punishment order. First paragraph need not go through the same because today I am only on the point of law. First, second, third paragraph. Third, fourth. In terms of para 15 of the West 2024. Have you lordship got my lord? Proceedings against under the invoking a provision of the non-est control order, punishment under a new control order. This is my case. I have been instructed, last line, kindly see, if you agree, prefer an appeal against the 2024 control order. These provisions which has been recorded, I can show your lordship, there is no punishment. So far fine is concerned, but I am not taking any point. My single point, control order has been invoked, which has no force at the date. Notice has been issued under the provisions of control order, no existence, punishment in a subsequent control order.
Now may I?
Okay. Now, what do you want now?
Quashing of this order? It
Quashing.
cannot stand.
May I make my submission now?
There are other grounds in the writ petition.
Yes, there are grounds I have taken. If your lordship kindly see the provisions, which provisions they have relied on. Kindly turn to page 24 once again.
Yes.
The provisions which has been relied on. Kindly come. First, second, third, fourth paragraph. In terms of paragraph 15 of the West Bengal Public Control Order 2015,
2024.
2024, this 15 has been relied on. Then, my lord, kindly see another provision. 45. The next paragraph, after that paragraph. This is therefore exercise the power conferred upon the undersigned in clause 45, 46 of the control order. Kindly take note of, my lord, the new control order. First, clause 15. Clause 15 says, at page, my lord, 9 of the control order. Possibly he is the WP. Kindly read, my lord, paragraph 15. Operation of the fair question. Subject to the duties and responsibilities as specified in clause 16, the dealer shall operate the fair price shop adhering to the provisions of the order in terms of condition of the so. I fail to understand what is the provision.
No, clause 45 and 46.
I am coming to that again. Clause 45 and 46. First, clause 45 at page by law 27. If the licensee without any complaint received against a dealer or suo motu in prima facie satisfied that the dealer is acting in such a manner which is prejudice to the interest of the beneficiaries, that with his whereby shop, or may hamper smooth implementation of public distribution, or may lead to law and order or so and so, it may immediately render the licensee under suspension, and after giving him an opportunity of hearing, if found guilty of any of the contravention so and so under the may, for reasons to be recorded in writing, impose punishment of either fine or reduction of the volume of business according to Schedule C. As well, Lordship, I shall show to Schedule Part 1, Schedule C, then kindly read paragraph 46. Punishment for black market, this is not the charge. Black market and match abbreviation. Now kindly see, my lord, paragraph 1, Schedule C. At page by law 39. Does your lordship found that there is a provision for any 3 times of the goods misappropriated? Only kindly come to 5. Right hand side. The licensing authority may.
You are referring page?
Page 39. Schedule C, Part 1. First, contravention of any of the provisions of control order. 2, any point of subclause, then kindly see fine 5,000, then 4, 5, 10,000, and maximum 20,000. Have you lost what manner? Page 39. You see, as we have indicated in clause 45.
39.
Minor. Kindly see, minor. Offense, top left hand side, schedule of
Part 2, Schedule C.
Part 1, Schedule C. Page 39.
Yes.
Schedule of penalty fine to be imposed upon the dealer for contravention of the provisions of the West Bengal Targeted Public Distribution System Maintenance and Control 2024. Next, serial number 1. Offense contravention under 11th clause. Contravention of any of the provisions of subclause 1 to 1 of the clause 6 or any of the components or so and so of subclause 1 of clause 45. Then 2. Fine of minimum rupees 5,000 for each of the contraventions committed by the dealer, which may be extended to maximum 10,000 for each contravention with an overall fine of 25,000. C4. Fine of minimum 10,000 for each of the contravention committed by the dealer, which may be extended to maximum 20,000 and maximum overall 50,000. So I am not coming 20 lakhs. Then kindly come the last one. The licensing authority may place dealer license under suspension immediately for a maximum period of 6 months, and within which, after giving an opportunity of being heard, and for the reasons recorded to in writing, reduce the volume of business up to 50% quantity, or impose penalty of rupees 20,000 for each of the contravention committed by the dealer, which may be extended to maximum 40,000 for each contravention with an amount of rupees 1 lakh according to the gravity of the offense. I am not also coming. This provision has been relied on.
Yes.
So, my lord, fine has been imposed, quoting a control order, provisions of a control order which does not match with the punishment. First point. Second point, so far the merit of the case is concerned, they have recorded in the show cause notice, on the basis of an complaint, inquiry has been conducted. No report has been handed over to me. I have not been intimated what those persons have lodged a complaint against me, what is the complaint. And my main point, which I have argued before Lordship, under a non-existence control order, no proceedings can be initiated. Your Lordship are dealing every day that no vacancy can be declared. It is a division-wise observation because it is honest, having no existence today. And more so, my lord, when the punishment has been imposed, that is in the under the new control order. The settled principle of law. If you start the proceedings under the provisions of law, which was existent, you should conclude the same under the same law. What my lord is required? So there is no existence. Had there been any show cause notice, I could have understand that has been issued prior to coming into force the new control order. That is the saving clause. Admittedly, 1st August, control order came into force, gazette notification. 7th August, alleged inquiry behind the back of my knowledge, without any copy of the complaint even. Subsequently, notice has been issued to participate in the hearing under the 2000 control order. Now, according to the whims and choice, the punishment under the latest control order.
Yes.
Quoting some provisions of law which has not been gone down in the control order itself. Huge amount of punishment.
Yes, Mr. Datta.
Lordship, my first submission I started that the mistakes in the writ petition should be corrected first by way of amendment. Because those have been verified as true to the knowledge of the petitioner. But I don't know whether supplementary affidavit is beyond my knowledge can rectify the mistakes or the incorrect statements verified as true to knowledge of the petitioner himself can be corrected by your filing a supplementary affidavit. In my submission, no, that cannot be done. So he first amend the petition and then come before Lordship. This is number one. Number two is if your Lordship takes the I take since he has placed the show cause notice and all. Lordship kindly comes to the show cause memo first 23rd. This is page 24 once. Page 24.
Yes.
Now, my lord, during an inspection at the FPS of such and such on 7th of August 2024, so and so, following irregularities were detected. Then Lordship kindly sees the irregularity. During the time of inspection, shortage of food grains was found as per following manner. A, Y, rice, so and so, were not very legible, my lord, I can read properly. Then 2, I am going. Dealer was found making only authenticated transactions through e-POS machine, but not making delivery of food grains to the beneficiaries at the same time, either at their doorstep or from the FPS. On the basis of the detected irregularities, a show cause notice was issued to dealer on 14th of August 2024. Lordship. Against the aforesaid show cause notice in written reply as well as in personal hearing, the FPS dealer took the following pleas. In terms of para 15 of the Control Order 24, the FPS dealer admitted the shortage of stock of PTS commodities. In terms of para 1613 of the Control Order 24, the FPS dealer admitted the making of only authenticated transactions through e-POS machine and not performing of Duare Rashan, but also denied the matter of not making of delivery of food grains to the beneficiaries. Then Lordship notes this to dealer admitted, and then observation, considering the aforesaid pleas vis-a-vis the charges brought against the FPS dealer, the following observations are construed in terms of para 15 line finance play. Dealer admitted the shortage of admitted the shortage. This is very vital. Admitted the shortage of stock of PDS commodities. So admission, it takes away the prior hearing or no violation of national justice goes because the admission is the conclusive proof of evidence. If somebody admits, then it goes to the root of the matter. Then Lordship kindly sees thereafter in terms of para 1613, so and so, the APS dealer violated the regulations by taking off only fingerprints through EPOS machine, but not making of delivery of footprints at the same time from his para mohalla of the assigned cluster of the day. Decision. Therefore, the extra power conferred upon the undersigned in clause 45-46 of the order 2024, a penalty of 22 lakhs 90,000 is thereby imposed upon Krishna Prasad Das, which is to be deposited in the manner of such and such. Then what it mentions the appeal against this order will lie before the district controller as per clause 1556 157 of the control order 2024. So, my lord, pausing here for a moment, my landlord has laid much emphasis on the existence or non-existence of the previous control order and the present control order. Now, it is a fact, my lord, that control order has taken away the previous two control orders. Now, 24 has come into existence. But kindly consider, my lord, the repeal and saving clause. Actions or steps taken under the previous that continue. It starts, but I don't have the book with me. My learned junior may help your lordship with the repeal and saving provision of the control order 2024, which specifically provides that anything done under the previous control order shall continue to have full effect. Repeal and logical, I think it starts with notwithstanding. That is non-obstante clause is there. Well, learned junior may read out for a lordship the repeal and saving
Page
provision.
35, madam.
Yes.
Notwithstanding such repeal, anything done or any action taken under the said repealed control order shall be deemed to have been done or taken under the corresponding provisions of this order.
Yes. So, my lord, it is very clear that with the coming into force of 24 control order, the acts or things done under the previous control order vanish. It's not that. That continue to have full force. And because of this having provision. Am I clear to Lordship, my lord?
Yes.
So, my lord, the point taken by Mr. Shaharai, my lord, with respect to subject matter doesn't lie because of the repeal as having provision of the control order 2024. And, my lord, the admission, my lord, your lordship knows I did not repeat. He has admitted that has been stated in twice or thrice. Lordship has seen that. There is admission that is regular and lastly, my lord, I shall submit this is a repeated offender. He was punished several times earlier. In 2023, he was punished with 20,000 penalty, then followed by another penalty of 40,000 for similar types of irregularities. So whether he deserves any consideration by a court of equity. In my humble sum, if I may, I cannot show to your lordship because here, I find in 2023 January 20th January 20, he was penalized with a fine of penalty of rupees 20,000, and on 13th of October 2020 he was penalized by a penalty of 40,000. So this is this third time. So he is a repeated offender. Then he doesn't deserve any consideration of your lordship, my lord. And my lord, lastly, my lord, the provision of appeal is there. If he is aggrieved, then he can prefer an appeal that is mentioned in the show cause itself. So, my lord, this remedy, alternative remedy, and my lord, there is no violation of natural justice doesn't arise. This question doesn't arise because he has admitted. So, the principle of natural justice, my lord, has no application in this case. So, my lordship, my lord, may direct my learned friend to come with an amended petition, and then in the meantime, I'll take full instructions in the matter, and then I'll come back to lordship. But my lordship may kindly not pass an interim order now, my lord, that it will go against the principles of law and my lord, the control order of 2024. It doesn't take away the operation of the act or thing done under the previous control order. Now, these are my submission for the day.
Yes.
I understood, my lord, so for law is concerned, only submission advanced on behalf of the state, repeal and saving.
Yes.
Just your lordship, kindly take note, because I don't think there is any ambiguity. Why my learned senator is arguing this point, I don't know. Clause 68, repeal and savings. The West Bengal Public Distribution System Maintenance and Control Act 2013 and the West Bengal Urban Public Distribution 2013 is hereby repealed.
Yes.
Then, my lord, next page.
There is no dispute about it thereafter. Non-obstante clause.
Yes.
Notwithstanding such bill, anything done or action taken under the Control Order 2013 under the corresponding organization shall continue. Anything done, steps taken prior to coming into force 2024 Control Order. That is prior to 1st August 2020. Next, all the cases already initiated against the licensee pending at any stage at the commencement of this order shall be dealt with. All the cases pending under 2013. Then, all the process of filing of the such vacancies and so on. So, all everything says, if any proceedings is initiated against a errand dealer invoking the provision of 2013 Control Order prior to 1st August 2024, then that will continue. There is no ambiguity. And your lordship knows in every saving clause, these are always there. Even 2013 Control Order, this saving clause was there. Because if I issued a shoppers notice under 2013 Control Order, prior to conclusion of Control Order coming into force 2024, I have to proceed on the basis of the 2013 Control Order. In this case, my second point is that you cannot take advantage of both the control orders. You are punishing me under 2024 Control Order without invoking the provision of 2013 Control Order. And so far the punishment part is concerned, I have shown to your lordship from the new Control Order. There is no such punishment in regard to 20 lakhs. 3 times of the amount of the shortage. Your lordship and so far your lordship knows this is the settled principle of law that admission is not at all a consideration. I have brought the judgment also before PS shows. Your lordship knows what in that case what happened. Electronic voting machine has been introduced without amending the Public Representative Act. A meeting was conducted. One person participated in the same meeting. He contested the election. He lost. Then came into the court. The other side took the point that after participation, you cannot take this plea. The Supreme Court says there is no principle of waiver if there is a violation of statute. Mr. Dottor, possibly I have gone through this judgment from his when I was in his chamber junior.
My lordship has not congratulated Mr. Devogol Saharai. He deserves congratulations.
This judgment, my senior has given me. Kindly turn my paragraph 38. Last but one. So well-known judgment.
May I know the citation?
AC Joshua, Mr. Dottor. 1984, page 656. You have given the citation 20 years back.
Paragraph
38. Lastly,
yes,
it was argued by the counsel for the respondent that the appellant would be stopped from challenging the mechanical process because he did not oppose the introduction of the process, although he was present in the meeting personally or through his agent. This argument is wholly untenable because when we are considering a constitutional or statutory provision, there can be no estoppel against the statute. And whether or not the appellant agreed or participated in the meeting, which was held before introduction of the voting machine, if such a person is not permissible or authorized by law, cannot be stopped from challenging the same. It's a very clear settled principle, and this has been followed subsequently also. This is one of K.K. Parma. Just one paragraph. In this case, what happened, my lord? A person participated in the selection process. He failed. Subsequently, my lord, he came before this honorable court challenging the findings of the act. Then court held that if there is a violation in the statute, and contrary to the statute, if any process is initiated, then participation does not debar him. This is well reported 2006, volume 5, Supreme Court cases, page 789, paragraph 24.
Paragraph 22.
Right. The same is 24, 2 short paragraph, small paragraph. Subsequent to the election process, initiation of the, whereas 60 marks are fixed for the written test and 20 marks for the oral. No mark whatsoever was allotted towards the performance. An endeavor has been made by the learned counsel for the respondent to contend that as the applicants were aware that no marks had been allocated in regard to the first performance, but despite the same, they having taken part in the examination were stopped and precluded from questioning the same. We do not agree. There is no violation. Kindly consider. This is a settled principle. And this is a case where the provisions have been invoked of a non-existent law. Subsequently, law came into force, trying to invoke the provisions of the new law, quoting wrong provisions. If your lordship allow the repetition, all right. Otherwise, your lordship finally stay the operation of the order. Let them come with the affidavit. Otherwise, one of the vacancy matters which have been passed irregularly by your lordship, that will also contrary to the law. And so far, other part is concerned, admittedly, no copy of the complaint, alleging complaint has been lodged, no copy of the report. I have no knowledge. They have went to, allegedly, they have went to some people's home and found that I have not given the rational articles, not in the shop room. So I'm paying for a stay of operation of the order of suspension.
Yes.
But these are my. And your lordship knows, this is the settled principle. If the foundation goes, superstructure falls automatically. If the so-called goes, my lord, then nothing remains. And if your lordship kindly see that so far the first order is concerned, no reason has been given also. What that judgment, I am not placing with your lordship. The reason is the heart of the determination. So it cannot stand, my lord. I have never seen that I shall start the proceedings under a law and conclude the same in another law. And I shall invoke a provision which has no existence, non-est, which is the basic of the division bench interim order also, so far vacancy matter is concerned.
Yes.
Well, these are my son.
Now, my lord, may I take my lord's leave, my lord? Another matter may be called on. May I take your lordship?
Very, yes, yes.
Lordship, I'm grateful. My learned Julian is here, my lord.
Please take down.
May I just come back, madam?
Yes. Petitioner is a FPS dealer carrying business of distributing ration article to the PDS holder. To the ration card holder. The respondent authority has conducted an inquiry at the ration shop at his ration shop on 7th of August 2024. Full stop. After such inquiry, a so-called notice was issued against the petitioner on 14th of August 2024. On the same day, a notice of personal hearing was served upon the petitioner. Subsequently, on 23rd of October 2024, an order of penalty, an order imposing penalty upon the present petitioner in respect of huge amount of money was passed by the concerned authority. Being aggrieved by and dissatisfied with the said order as well as the proceeding initiated by the respondent authority, the instant writ petition has been preferred. Full stop. Mr. Devabrata Saharai, learned counsel, appearing on behalf of the petitioner, submits that repealing the West Bengal public distribution system within bracket maintenance and control bracket close order 2013, the new control order was introduced on 1st of August 2024. Full stop. The earlier control order 2013 has been repealed. Full stop. He submits that the so-called notice was served upon the petitioner on 7th of August 2024, mentioning the repeal control order of 2013. The notice of personal hearing also indicated the repeal control order 2013. But when the impugn order of punishment was passed, it mentioned the new control order of 2024. He submits that the control order which has already been imposed on the basis of which which has already been repealed, on the basis of which the so-called notice was served, that is tantamounts to be non-est in the eye of law. He further argued that no punishment can be passed on the basis of such so-called notice on the strength of the repeal control order. In support of his contention, he cited the repealing provision, that is clause 68 of West Bengal Public Distribution System Maintenance and Control Order 2024. Mr. Sahara further submits that there are several discrepancy in the instant order imposing punishment, so the order need be quashed. In support of his contention, he cited decisions of Honorable Apex Court passed in AC Jose versus Sivan Pillai and others within bracket 1994 to SCC 656, paragraph 38. একটা বলবে কে next para Parmar and others versus High Court of Gujarat within bracket 2006 5 SCC 789. আচ্ছা সেটা হচ্ছে paragraph 24. Mr. Swapun Dotto, Learned Counsel, appearing on behalf of the state authority, has submitted that the writ petition is not at all maintainable, as the writ petition has disclosed the award of punishment to be 7 lakh. Petition contained the imposition of fine. Has disclosed the imposition of fine of rupees 7 lakh. Actually, it is not such, but it is about 23 lakhs. He further submits that by way of supplementary affidavit, the error in the writ petition cannot be corrected. Next para, Mr. Datto further argued that by the repeal provision, it has been specifically stated that any action taken in pursuance of the Control Order 2013 may be carried or continued by virtue of the relevant provisions of Control Order 2024. Next para, Mr. Datto further argued that the impugned order of punishment specifically depicted the clear undertaking and declaration stroke admission of the petitioner for shortage of stock of PDS commodities in the commodities in his shop room. When the admission has been made at the time of hearing by the petitioner himself, the chance of violation of natural justice cannot be construed. He further argued that there is a specific provisions of filing appeal before the concerned authority against the order of suspension. They argued that the writ court shall not entertain the writ petition stating writ petition on the attending facts that the present petitioner is a habitual offender. Full stop. Next paragraph. Having heard the learned counsels for the parties, it appears to me that the petitioner has filed a writ petition containing inter alia that the respondent authority has imposed fine upon him by an order amounting to ₹7 lakh. However, by filing supplementary affidavit, they have stated that the said amount would be 22,90,689. The matter is in respect of an impugned order of punishment, which itself filed before this court. So at this juncture, I should not be concentrated over the wrong entry of the amount in the instant writ petition. Full stop. Next paragraph. The issue involved in the instant writ petition is that whether the service of show cause notice mentioning the wrong provision of law stroke repeal provision of law and the proceeding thereof which culminated to an order of imposition of fine can be allowed to be continued. It is true that when show cause notice was served within bracket 14/8/2024, the WPDS MNC order 2013 has already been repealed and its place WPDS control order 2014-2024 has been introduced. Full stop. However, the notice of personal hearing also mentioned the WPDS MNC order 2013. But while imposing punishment, the authority concerned has imposed the punishment in terms of clause 45/46 of WBPDS MNC order 2024.
My lord, only one thing, my lord. May I bring to the notice of the lordship one carrying down was issued by the department to the petitioner before the date of hearing.
আমায় দাও কপি দাও
So will be a copy of petition for that was issued before the date of hearing.
One Korean was issued in respect to the show cause notice. Yes.
Yes. That meted.
কি বললাম বলো? The respondent authority has also handed over a copy of Corriendum dated 27th August 2024, wherein it has been mentioned that the control order was wrongly mentioned in the show cause notice. Full stop. The law has been specifically discussed by the Honorable Supreme Court in AC Jose Supra as well as KK Parmar on the principle that there is no estoppel against the statute. It is the ratio of the decision of the Supreme Court that though a party has participated in a proceeding, but the said party cannot be debarred to challenge the statute in the latter proceeding. It is true that the so-called notice was served upon the petitioner on the basis of a non-est control order. The jurisdiction of this writ court to entertain a writ petitioner is only on the principle of whether the petitioner has been deprived by the arbitrary action of the respondent authority, arbitrary or biased action of the respondent authority. The term of violation of principle of natural justice had its extreme height up to the sky, to determine the true purport of the meaning of violation of natural justice. It has to be understand that whether the petitioner has been at all prejudiced by the order of by the act and action of the concerned authority. In this particular case, the so-called notice was issued upon the petitioner on the basis of a wrong quoting of on the basis of a repeal control order. However, the petitioner was well aware about the fate and facts of the so-called notice. It further appears to me that the service of so-called notice by mentioning the repeal control order, repeal provisions of control order, has not at all prejudiced the present petitioner. Furthermore, the impugn order of imposition of punishment itself depicted that the petitioner has admitted before the authority there are some shortage of stocks. Thus, it cannot be said in this case that the principle of natural justice has been violated by issuing a so-called notice wherein a provision, wherein a clause of repeal control order has been mentioned. Considering the above aspect, I think it necessary not to interfere at this stage with the proceeding as initiated by the present petitioner, by the concerned respondent authority. However, the petitioner has every opportunity according to the control order to challenge the order of punishment as imposed upon him by preferring an specific appeal before the DCF and S concerned. The delay in full stop. At this juncture, I find no justification to entertain the instant writ petition. The delay in preferring the instant, the delay in filing the appeal would be condoned if the petitioner has approached the appellate authority within 4 weeks from the date of passing of this order. Under the above observation, the instant writ petition is disposed of.
Your Lordship is suggesting for preferring appeal.
Yes, preferring an appeal.
Number 9, time for the
Yes.
Or in this matter, the Association of Fair Price Shop Dealers recognized registered association is coming before your lordship. Petition number 1 is the association, and petition number 2 is the general secretary. They are challenging the virus of the West Bengal Targeted Public Distribution System Maintenance and Control Act 2024.
Yes.
Just before submitting the merit of the case, just short, but your lordship knows section 3 of the Essential Commodities Act empowers the central government to frame rule for controlling essential commodities. Section 5 empowers the central government to delegate the power to frame rule by the state government in exercise power under Section 3 of the Essential Commodities Act. But in Section 5, there is a specific content that power should be delegated to the state. That power should be delegated to the state by issuing a specific order mentioning therein how and which manner state government shall frame the rule. You will also kindly take the book first.
I think it's interim order চাইছো তো?
Punishment হচ্ছে
Honesty হচ্ছে না তো। এটা বলে- My lord, may I only intervene, my lord? My learned friend is challenging a statute or a subordinate legislation. But I have got two fundamental points. Number one is, my lord, the passing of a statute does not give rise to a cause of action. Therefore, my lord, my learned friend should first show that how the statute is today affecting him. It may affect him tomorrow. If tomorrow it affects him, tomorrow he gets a cause of action. But today, by dint of passing of a legislation, whether it is subordinate legislation, whether it is a parent legislation, my lord, that does not give rise to a cause of action. My lord, there is a Supreme Court judgment, number one. And number two, my lord, the passing of a legislation cannot possibly be challenged by an association because the association cannot get affected by it. Maybe its members get affected on a case-to-case basis.
Yes.
And thirdly, I don't think we are even keeping the point of maintainability open, Miller. If your lordship may kindly direct us to come back after filing affidavits, because today, Miller, there cannot be a question of stay of a statute.
Let me hear it out.
Take up, my lord, Section 3 of the Act. At page, my lord, 14, first.
Yes.
Power up to control production, supply, distribution, etc. of essential commodities. If the central government is of the opinion that it is necessary or expedient for maintaining or increasing supplies of any essential commodity, or for securing their equitable distribution and availability at fair price, or for securing any essential commodity for the defense of India of the effective conduct of military operation, it may by order provide for regulating or prohibiting the production, supply and distribution thereof and trade and commerce thereof. Then 1A, notwithstanding anything contained in subsection 1, the supply of such goods including sales so and so kindly turn to B. Any action or imposing stock limit, then B1 100% so and so, 50% increase of so and so, or the price so and so, and the they will also kindly come to 5, section 5 of that. Going to kindly come to section 5. Delegation of power.
Yes.
The central government delegation of power. The central government may by notified order, kindly take note of it, direct that the power to make order or issue notification under section 3 shall in relation to such matter and subject to such conditions, if any, as may be specified in the direction, be expressly also by such officer or authority subordinate to the central government, or such state government, or such officer or authority subordinate to a state government. So, delegation of power can be invoked by the central government under section 5 of the Act.
To the state government or the officer of the state?
State government shall frame the rule and exercise power under section 3.
Under section 5.
Also say that there should be notified
Yes.
empowering the state government and fixing the terms and conditions. Once again, I am reading this portion. The central government may, by notified order, direct that the power to make orders or issue notification under section 3 shall in relation to such matters and subject to such conditions, if any, as may be specified in the direction, as may be specified in the direction in exercise also by so and so. As may be specified in the order to be notified by the central government, empowering the state government to frame rules in exercise power under section 3 of that.
Okay.
Well, your Lordship knows the National Food Security Act came into force 10 September 2013. If you will kindly take up page 24 of my writ petition. National Food Security Act. 10th September 2023 at page 24. Just first paragraph, if you also kindly read, what is the purpose of enacting this act? After 67 years of independence, central government framed this rule, targeted public distribution, targeting a section of the person of a society to provide food. Kindly, I am reading well at the first paragraph. An act to provide for food and multinational security in human life cycle, approved by ensuring access of adequate quantity of quality food and affordable prices to people to live a life with dignity and for matter concerned here in so. Be it enacted by Parliament 64th year of so. That is all called National Food Security Act in extension to the whole of India. Then kindly turn the page, madam, next page. But your Lordship knows 2013 control order has been framed previously in exercising power as provided by the central government 2001 public distribution system control. At that material point of time, there are 4 types of ration cards. That is called APL, BPL, Antoday, and AAY, Antoday Anna Yojana. Now, your Lordship, kindly come to page 25, clause 3, eligible household. This BPL concept, APL concept, all has been overreached by today. Kindly see, my lord, means households covered under the priority households and the Antoday Anna Yojana referred to so and so. Now, my lord, there are 2 types of ration cards. Yes. Eligible households and Antoday Anna Yojana. And eligible households has also been described in 2 formats. One is priority household, another is special priority household. So we can say, my lord, today instead of 4 categories of ration card holders, now there are 3 categories. Out of that, my lord, BPL card holders, APL card holders, and Antoday Anna Yojana has been repealed. Then fair price shop definition has been given, means a shop which has been so and so. Then kindly come to my lord, next page. Clause 23. Definition clause.
Yes.
Targeted public distribution system means the system for distribution of essential commodities to the ration card holders through fair price shops. Then chapter 2, provisions for security. Every person belonging to priority household I have submitted before your lordship, identified under subclause 1 of section 10 shall be entitled to receive 5 kilograms of food grains per person per month as subsidized prices specified in Schedule 1 from the state government under the targeted public distribution system. Provided that households covered under the Antoday Anna Yojana shall, to such extent as may be specified by the central government, for each state in the state scheme, there is been entitled 35 kilograms of food grains per person. So, quota of ration for ration card holders has been fixed in all over India. Because one of entire ration articles, your lordship knows, provided by the central government at a subsidized rate, and the state government implements such scheme. Now, your lordship, kindly come to the next page. Clause 7. The state government shall implement scheme covering entitlement under section 4, 5, and section 6 in accordance with the guidelines, including cost sharing between the central government and the state government in such manner as may be presently by the central government, as may be specified by the central government. So far the ration articles are concerned, entire price by the central government at a subsidized rate. So far mechanism is concerned. That is meanwhile margin of the dealers, margin of the distributors, that shall be governed by the scheme to be framed by the central government. It can be 50% ratio or 75% to 85% ratio. I shall
No,
show you.
the state government shall implement scheme covering entitlement under the section 4, 5, and 6 in accordance with the guidelines,
My lord,
including the cost sharing
my lord.
between the central government and state government in such a manner
That's
that
the
it is
described
kept in the central
subsequent clauses. I shall show you.
Okay.
Lordship. Now, your lordship, kindly come to page 29. Clause 16(1). Every state government shall, by notification, constitute a state food commission.
You are reading clause 29.
Page 29. Page 29, clause 16.
Clause 16.
Middle portion of the page. State Food Commission, left hand side. Middle portion of the page.
Yes.
Every state government shall, by notification, constitute a state food commission for the purpose of monitoring and review implementation of the act. I have made out a case that this commission has not yet been constituted, but they are enforcing this control order. Now, kindly come to my page 31. Chapter 8, obligation of the central government for food security.
Yes.
The central government shall, for ensuring the regular supply of food grains to persons belonging to eligible households, allocate from the central pool the required quantity of food grains to the state governments under the targeted public distribution system as per the entitlement under section 3 at prices specified in schedule 1. The central government shall allocate food grains in accordance with the number of persons belonging to the eligible households identified in each state under section so and so. I shall show to your lordship from the control order, central control order, or this act. The number of people of the every state has been fixed. They are entitled under this scheme, that is National Food Security, to get the ration at a subsidized rate or free. And quantity of the food grains to be supplied to the every state is also fixed. I shall show to your lordship from this act. Now, your lordship, kindly turn the page, next page. Page 32, chapter Roman 9. Obligation of state government for food security. The state government shall be responsible for implementation and monitoring of the schemes of various ministers and departments of the central government in accordance with the guidelines issued by the central government for cash scheme and their own scheme for ensuring food security to the targeted beneficiaries of the state. Under the targeted public distribution system, it shall be the duty of the state government to, duty of the state government, kindly take note of, take delivery of food grains from the designated depots of the central government in the state at the price specified in Schedule 1, organize interstate allocations for delivery of the allocated food grains through their authorized agencies at the doorstep of each of the fair price shop. So goods should be reached to the doorstep of the ration dealers by the agencies of the state government.
Yes.
B, ensure actual delivery of supply of the food grains to the entitled person at the prices specified in Schedule 1. That is also there, my lord. Page 35, you will also kindly take now.
Yes.
Now 39(1), clause 39(1), page 35. The central government may, in consultation with the state government and by notification, make rules to carry out the provisions of this act. Invoking these provisions, central government in 2015 framed the targeted public distribution system control 2015 by repealing 2001 control order. Now you will also kindly say power of the state to frame rule, clause 40. Section 40, sorry, section 40.
Yes.
41. The state government may, by notification and subject to the condition of previous publication and consistent with this act, take note of consistent with this act and the rules made by the central government, make rules to carry out the provisions of this act. I have shown to your lordship section 5 of the Essential Commodities Act, delegation of power,
Yes.
by issuing a notified order, fixing that terms and condition to be followed by the state government. Now you will also kindly come next page, page 41. No, sorry, my lord, page 41. Well, this is the schedule 4, state-wise allocation of food grains. Now, left-hand side, name of the state. Your lordship, kindly come to serial number 29, West Bengal. Have your lordship got my lord?
Yes.
Now your lordship, kindly right-hand side, quantity in lakh tons. 38.49 lakh tons food grains has been fixed so far the state is concerned, or state is concerned.
Yes.
Quantity of every state has been fixed by the central government. This quantum should be delivered to you for provide to the ration card holders through your agencies and fair price shops. Now you will also kindly see the next page. This is the 2015 Targeted Public Distribution System Control Order framed by the central government for implementation of National Food Security Act 2013.
Yes.
But first paragraph, you will also kindly see, whereas the central government is of the opinion so and so, food grains under the targeted public distribution. Then second paragraph. Now, therefore, in exercise of the power conferred by section 3 of the Essential Commodities Act 1955 and in supersession of the Public Distribution System Controller 2001, public distribution, except as repealed things done or omitted to be done before such supersession and save as otherwise provided, that the central government hereby makes the following order, namely, the order may be called Targeted Public Distribution System Maintenance and Control 2015.
Yes.
For implementation of National Food Security Act, new rule has been came into force in the 20th March 2015, repealing the previous central control order of 2001.
Yes.
Now, Lordship, kindly turn to page 44. The definition clause I am reading is 2J, 2I, 2GHI, J, 2J, my lord, bottom of page 44. Fair price shop owner. Definition of fair price shop owner. Means a person and include a cooperative society or a body, corporate or a company of a state government or a Gram Panchayat or any other body in whose name shop has been licensed to distribute essential commodities under the targeted public distribution system. But pausing for a moment, my lord, it says who are entitled to get license of the fair price shop, which includes, my lord, cooperative society, government company also. Why I am saying so? Without license, nobody can distribute the ration articles.
Yes.
Even a state government agency or state government company, license have to be given to them. Immaterial to the fact, other definitely they have to obtain also. But even state government authorities, if engage a state corporation or state company, license have to be provided to them also. Kindly turn the next page, my lord, page 45. The definition of Food Security Act has been given. K, Food Security Act means the National Food Security Act 2013. Then state will also kindly turn to page 50.
Yes.
Clause 4, ration cards. The state government shall issue ration cards to the eligible household as mentioned in the final in respect of under subclause 12 of the order, provided that while issuing ration cards to the eligible households, the state government shall ensure that the coverage of the number of eligible households is not merely done with a view to exhaust the state-wise ceiling of number of so and so. This says quota has been fixed. Suddenly it was found number of ration cards reduced. only to reach that target, state government cannot issue the ration cards who are not entitled to get the commodities from the central government. To reach your quota, which has been fixed by the central government.
I understand.
My lord. My lordship, kindly come to page 53. Clause 14. The designated authority shall issue a ration card to an eligible applicant within a reasonable time, not exceeding 1 month of the date of receipt of this application after necessary checks and verification.
Yes.
So if any person applied for ration cards, that should be considered and card should be issued at earliest possible, but not later than 30 days. I shall show to your lordship from the state control order, there is no such mentioning. Even a person have to wait, my lord, 1 year or 2 years also after application. Now, your lordship, kindly come to page 60.
Yes.
Clause 9, the licensing and regulation of fair price shops. This rulemaking power has been provided to the state government. Kindly see. The state government shall issue an order under section 3 of the Act, but not inconsistent with this order, for regulating the state, for regulating and sell the distribution of the essential commodities, which I have shown to your lordship under section 5 of the Act.
Yes.
Not inconsistent. Kindly take note of. Whatever rule you are going to frame, you have to frame the same in consistence with this central control order.
Yes.
The next page, your lordship, kindly see another clause I shall show to your lordship, page 61. Clause 5. Of course, what to clause it is 9. But 9 sub clause 5. The license to the fair price shop owner shall be issued keeping in view the validity of the fair price shop. Viability of the fair price shop. But this is very important.
Viability of fair price.
My lord, economic viability.
Yes.
You are going to declare vacancy for appointment of dealers, where there are only 5,000 ration cards, 3 vacancies. You have to first ascertain the economic viability of a dealership.
Yes.
According to your whims and choice, you cannot distribute the license, making the dealership business economically unviable. Today, there is no scheme, no formula. What will be the economic viability of a ration dealer or a shop?
Yes.
How many cards is required to be tagged to make the dealership business economically viable? This is the choice of the licensing authority or the district controller or the director. In some cases, there are 10,000, 12,000 cards continuing for last 20 years. In some cases, 400 cards, fresh vacancies being declared with 2,000 or 1,500 cards. That has been stopped by the central government. You first ascertain to make the dealership business economically viable, what number of cards is required to be tagged with a dealer, individual dealer. The next point, my lord, kindly see the next paragraph, subclause 6. The state government shall ensure that the number of ration card holders attached to a fair price shop are reasonable. Reasonable means, my lord, economically viable. A reasonable number of cards must be tagged with a dealer.
Yes.
The next page, your lordship, kindly see subclause 7 of clause 9. The margin. The state government shall fix an amount as the fair price shop owner's margin, which shall be periodically reviewed for ensuring sustained viability of the fair price shop operations. Viability of the operators. Submitted before your lordship, so far the price of the commodities are concerned, entirely central government. So far mechanism is concerned, in some cases 50% shall be borne by the central government. In some cases 25% shall be borne by, this is the scheme. Then my lord 9, clause 9, subclause 9. The state government shall allow sale of commodities other than the food grains distributed under the targeted public distribution system at the fair price shop to improve the viability of the fair price shop operators. But that has been followed, my lord. I should not have mentioned this clause 9. Then kindly turn to my lord, page 71. But this is clause 14 at page 71. Power of search and seizure.
Yes.
An officer authorized by the state government shall be competent to inspect or summon such records or documents as may be considered by him necessary for examination and take extract of copies of the records, so and so. So, my lord, by particular designation has to be fixed. Who can enter, who can take coverage of this inquiry or so and so. Now, your lordship, kindly come to the next page. Search seizure provision has been dealt with. I am not reading. Kindly come to my lord, subclause 5. The provisions of 100 CRPC is to be recorded. Appeal provision is there. The state government shall appoint officer of the state government not below the rank of. Now, kindly state where your lordship come to page 74.
Page 74. Yes.
Pending the disposal of an appeal, the appellate authority may direct that the order under appeal shall not take effect to such period as may the authority may consider necessary for giving reasonable opportunity to the other party under subclause 1 until the appeal is disposed of, whichever is allowed. So, there is a provision in this control order that during pendency of an appeal filed by any errand dealer, stay can be granted.
Yes.
Not to give effect to that. The next page, your lordship, kindly turn up. West Bengal Targeted Public Distribution System, Control Order 2020-24.
Yes.
Page 75, your lordship, kindly 76, your lordship, kindly turn up.
Yes.
Dated, my lord, notified on 1st of August 2024. Have you lordship got the date?
Yes, got it.
Just last paragraph I am reading, my lord. Now, therefore, the governor is in exercise of power conferred under section 3 and section 5 of the Essential Commodities Act 1955, read with the government of the Ministry of Consumer Affairs, Food and Public Distribution, order number so and so, so and so. That order I have just placed before 2015, so and so. Short title of government, the order may be called the West Bengal Targeted Public Distribution System Maintenance and Control 2024. Well, the entire scenario has been changed. Now it is Targeted Public Distribution System. Now kindly turn the page, next page. Definition of dealer has been given to clause E of the Controller 2024. Then kindly turn to my lord. Definition of fair price shop at subclause J, definition clause. Then K, your lordship, kindly turn. The definition of family member: spouse, parents, son, including so and so, son's daughter, son or daughter, so and so, brother, or so and so. Well, this definition means, my lord, your lordship, considering so many matters, so far the compulsory appointment is concerned, they are only person who are entitled to get the license on compulsory account, having no means of earning. This is also being used while a vacancy is notified. They have been debarred to make any application.
If the family of the person applying for the license is had a license.
So, my lord, brother, sister, one brother residing in Kakdip have a license of fair price shop. His sister resides in Darjeeling. No relation. Sister cannot apply if any vacancy is notified in Darjeeling. Kindly consider these aspects of the matter. For last 30 years, I am residing in a distant place, having no relation. But since my brother or sister have a license, in a distant place, if any vacancy is notified, I cannot apply for that. Whether that takes away my fundamental right or not, to do rightful, lawful business. Now, Your Lordship, kindly, I shall enlarge my argument by showing the provisions of relatives also. Kindly turn the page 78. Clause subclause R, place of business. This is very important.
Relative.
Place of business. No, I am
Place of business.
my lord. Means a place in the shop cum godown of APS owners and in any office in the approved godown or adjacent to an approval godown or distributor where books of accounts are kept. So my place of business is my shop room, licensed shop room. I shall run my business from the room which has been recorded in my license. I cannot be forced to run my business from a place which has not been recorded in my license. Licensed shop room is my place of business.
Yes.
Unless the shop cum go down or shop or go down is approved, meaning thereby recorded in my license, I cannot keep any ration articles in any other place. I cannot run my business. I cannot distribute my business ration articles also to my consumers. Now, my lord, kindly come to the clause.
What is your objection here?
My objection is that a new policy has been adopted by the state government. That is dual ration scheme, directing me to deliver the ration articles to the doorstep of the consumers, which barred me so far this clause is concerned. Business mean distribution of ration articles.
Yes.
Except the license premises, I cannot distribute ration articles. That is the scheme of the central government also.
No, dual ration scheme must have depicted that the ration article has to be hand over to the
from my shop room
to the ration holder to the
at their doorstep.
At their doorsteps.
Doorstep.
So you
I
are
have
saying,
to go to their shop.
So you are saying that is a contradictory.
Absolutely. I cannot be forced to deliver ration articles to the house of a rationee.
So what is your challenge here in the writ petition? These anomalies.
These anomalies. And there are two other points. Well, relatives definition is also there, Your Lordship has seen.
Yes.
So, my lord, son, brothers other than the brother, daughter, spouse. Even my brother-in-law or sister-in-law resides in a distant place. If any vacancy is notified, they cannot apply for the same. On the contrary, they cannot be entitled to get license on compulsory ground also. Double jeopardize. Kindly see the relationship. Brother's sister, brother's wife, sister's husband. They have also been debarred to apply for any dealership if brother-in-law, sister-in-law, brother's brother hold a dealership license.
Okay.
My lordship, kindly come to page 79. I have shown to your lordship from the central control order that ration card must be handed over to the applicant within 1 month maximum.
Yes.
Kindly see, my lord, the provision which has been mentioned in clause 4, ration card, issuance of ration card. Your lordship need not go through the entire paragraph. Kindly come to my lord. Subparagraph 5. Every application so received shall be disposed of within such period as may be specified by the state government from time to time. Nothing has been specified. Unlimited period. Why I am saying so, my lord? I am a dealer. How I am become prejudiced? I have 2,000 cards. 100 or 200 person died for a during period. And there are 200 applications also. If the authority concerned kept pending those cards, this quota food grains will be dealing from me.
Yes.
I shall not be entitled to get margin of that quota.
No, after issuing the new ration card, the quota would be.
I shall be. But if they kept pending for years together, that caused suffering to the dealers.
Not the dealers, to the ration card holders also.
No, I am saying because, my lord, kindly consider these aspects. I am a dealer. Say 5,000 card has been tagged with me. Just take note of that within a year, 200 card has been not operated. Either left the place or
died.
Likely, there are 200 applications also pending. If that is considered and card is delivered immediately within 1 month, so I shall not be prejudiced. The quota which is being given to me, that will not be reduced. If they kept pending for years together these applications for ration card, my quota will be deducted.
Your business will be suffered economically.
Right. Now, your lordship, kindly come to page 81. Licensing or fair price shop, chapter Roman 3.
Yes.
Clause 9. Procedure for creation of fair price shop and appointment of licensee. The state government in public interest and the interest of the beneficiaries must rationalize the number of ration cards to be tagged with the fair price shop.
Yes.
But today, nothing has been fixed. There is no determination to make the dealership economically viable. How many number of cards are required? The entire decision by the licensing authority or the higher authority. Which number of cards shall be tagged with a new dealer, or which number of cards shall be dealing from an existing dealer to make the dealership business economically viable. Till today, no decision has been state government taken. Although central controller with no uncertain terms says the reasonable number of cards should be tagged with the individual dealership to make the dealership business economically viable.
Yes.
Now, your lordship, kindly come to part 2, state government to grant license. This is also there. Then kindly come to next page. Clause 11, subclause 5. The individual applicant or partnership from the partner in the partnership firm must be above 21 years of age and below 45 years. Who can apply for the dealership? After 45, you cannot. Kindly take note of a dealer 50 years of age or 40 years of age. There is a provision for compulsory appointment. His widow's age is 46 years. She cannot apply for the dealership on compulsory ground. There is no relaxation in the compulsory ground also. This is very usual. 52 age, a dealer died, having only widow. Age 45 plus. She will be debarred to apply for dealership on compulsory ground.
Okay.
In my lord, the Roman 7, the appellate for dealership must have such financial capability as the state government may by order different. This has also not been fixed. Roman 7. Then kindly come to my lord. Clause 12. Disqualification to get a fair price shop license on and after commencement of this order, following category of persons are not eligible to apply for license of a new fair price shop. A. 1. A person holding a license of dealer or distributor in the manner of the person whose relative already have a dealer or distributor license as an individual or a partner as an the official bearer of self-help group, so and so on. They have all have been tapered. So family members, including relatives, I have given the reference. My brother-in-law is a dealer of Pakdeep. I am residing in Shiliguri. A vacancy has been notified in Shiliguri. I have been debarred to apply.
Yes.
Then you also kindly see the clause 6, Roman 6 of the same page, 12.6. A person of unsound mind, he also cannot apply. Absolutely, my lord. And an insolvent. What is the meaning of insolvent? How much money is required to make a person solvent? There is no clarification, no prescription.
And person declared
Unsound mind, I
insolvent.
declared by a appropriate civil court of law.
Insolvent is not capable of make contract with any person.
Insolvent declared by the court of law.
Yes.
If that is so, my lord, that is no case. I cannot make out a case. Insolvent means, according to dictionary meaning, then it is all right.
Yes.
But if they take advantage of this, you have no money, you cannot apply for the same. On the contrary, I have to deposit rupees 50,000 to show up my bank balance at the time of making application. If it is dictionary meaning, if it is in terms of the civil procedure code, a person insolvent, that is, then it is all right. I shall pray for your lordship a clarification so far this point is concerned. Now your lordship kindly straight away come to page 84.
Yes.
My lord, operation of the fair price shop, clause 15, 16, duties and responsibility of dealer. Kindly turn the page. Duty and responsibility has been categorized. Then kindly turn over page 86, clause 7, manner of distribution of public distribution. That is there. Then kindly turn to Yes. Well, kindly turn to page 87, clause 20.
Yes.
Provision to resignation by a dealer. Well, this is very important. A dealer may resign by giving a notice under his hand addressed to the licensing authority, but he shall continue to run the fair price shop until his resignation is accepted by the licensing authority. But this is a settled principle. I have the right to do lawful business. I have also the right not to do any business. If I make an application for resignation, even for medical ground, it is the discretion of the authority concerned when they will accept it. And till such time, I have to continue the business. Unless it is accepted by the licensing authority. Even if I am a medical unfit.
Milord, Mr. Shara is going to continue rest of the half, Milord. May I take your lordship's leave, Milord?
Now, what is the issue there in this writ petition?
I shall come in my best issue, the provision for penal action.
Okay.
which suggests no show cause is required.
No, very well. So what you want in this writ petition?
Today I shall pray for declaration of ultra virus for various grounds. But today my prayer is, at least, your lordship knows this is the settled principle. The provision for penal action says, by issuing a notice calling the dealer concerned to participate in the hearing, the licensing authority may terminate the license. Even what is the charge, that may not be intimate to the person concerned.
Without
The
issuing
basic
a
principle.
show cause notice, there is no
Only
provision
notice.
for issuance of show cause notice.
No, only notice. Notice mean for notice of hearing.
Notice of hearing.
Intimating the date and time only. I don't know what is the charge. I shall go there. I shall make my submission. They can terminate my license. This is contrary to basic principle of natural justice. A person should not know what is the charge against him before going to the hearing. May I place that question, my lord?
No, I understand. So this matter cannot be disposed of without hearing or without giving an opportunity to contradict that
But
point.
This part is concerned, I am paying for stay.
Only
punishment parts.
Only this part can be disposed of within 7 days.
Milord, this writ petition.
No, not writ petition. Only this point.
Yes.
Only this point, not the other ground, other anomalies like that.
Milord, I have indicated my points, Milord. Number one, Milord, whether the writ petition is maintainable at the instance of an association or not. Number two, now he has confined his argument or the point to the penalty clause.
Yes.
That penalty clause also, Milord, unless, Milord, the penalty clause is applied, there cannot be, Milord, any grievance in the vacuum. Well, this is a grievance in the vacuum, because all the statutes, most of the statutes have a penal clause. So the fact that there is a penal clause or that there is some ex facie irregularity, as he is saying, in the penal clause, Milord, that itself is not a ground of challenge. Number three is, Milord, if he is asking for a stay only in regard to the penal clause, then also, Milord, the Supreme Court has said that in a case of challenge to a primary statute or to a subordinate legislation, Milord, stay can be granted only if, number one, it is ex facie unconstitutional.
Yes.
What he says is that you are not giving me the charges. You are not making me known of the charges. This is as I could gather. Now, if that is the procedure, then also, Milord, it is not ex facie unconstitutional. And, Milord, added to that, to get an interim order, Milord, the other three principles, Milord, prima facie case, balance of convenience, and Milord, irreparable loss and injury, Milord, these are the collective factors. Yes. Now, Milord, I can immediately recollect of a case, Milord, of this was in the education department, where, Milord, these kinds of provisions were challenged, which ultimately went up to the special bench of Justice Zumapal. Judgment is named Arun Kumar Haight. Just from my memory, I am saying, where, Milord, the same questions arose.
Yes.
That the law does not lay down the compliance of principles of natural justice. This is what is this case, that you are asking me to go for the hearing. You are not
You're not aware about the charges.
aware about the charges, and
penal action,
and you will take an action. Assuming for argument's sake, whatever is he's saying is correct. I have my own version of it, be that as it may. Then, assuming for argument's sake that it is correct, then also, Milord, our special bench has held that the principles of natural justice is imbibed in it. Okay. So an authority, before taking an action, will provide whatever is the charges, etc. Therefore, Milord, this cannot call for a stay, and a stay on this, Milord, will have a devastating effect.
Yes.
People will go on, Milord, violating the law, and the state cannot take any action against them. But that is another aspect, Milord. Your Lordship may, on this point, hear me on a day, but I'll bring those judgments, including that Arun Kumar Haight, where it's read into it. Milord, kindly recollect, Milord, our Mr. Shahara and myself, Milord, we learnt in the same chamber together, Bina Pani Dei's case, that it is inbuilt in it. I will bring those judgments for your lordship's consideration.
Okay.
হাতি
So,
হবে আমাদের।
okay, please take down. I am fixing a date on December
sir.
first week.
But except 3rd December. Except 3rd December anyway.
3rd December.
Thank you so much.
So on 4th then, Wednesday? Okay. The instant writ petition was preferred.
Could I take your lordship's leave?
Yes,
sir?
yes.
I'm good.
Was preferred,
Fourth.
challenging some provisions of West Bengal Targeted Public Distribution System Maintenance and Control Order 2024, which is not inconsistent with the provisions of Targeted Public Distribution System within bracket control order 2015 issued by the Ministry of Consumer Affairs, Food and Public Distribution System. Ministry of Consumer Affairs, Food and Public Distribution. Affairs, Food and Public Distribution, dated 20th March 2015. Next para Mr. Saharai. Appearing on behalf of the petitioner, seek necessary order of stay in respect of the penal provision enumerated under the West Bengal Targeted Public Distribution System within bracket maintenance and control bracket close order 2024, arguing that there is no provisions made for issuance of show cause upon the alleged erring licensee. Erring licensee. Full stop. He submits that no penal provision can be enacted in a statute without a specific provisions of issuance of show cause. He submits that the entire provisions of initiation of penal action is unconstitutional. Full stop. Heard the learned AG appearing on behalf of the state. It appears that the AG seeks and weak accommodation seeks a weak accommodation to demonstrate the matter before this court. Let the matter appear in the list on 4th of December.
4th of December at 10:30.
10:30.
At 10:30, there are other matter 50. Also, kindly item number 1, because Mr. Advocate General told me possibly this is also my matter. That matter your lordship is hearing yesterday, Antara Gadgi, possibly that matter.
Yes.
Antara Gadgi.
Okay.
So fix it at 10:30, item 1, because Advocate General requested me to mention for your lordship.
10:30.
10:30, item 1, because otherwise, other 10:30 matter.
Whether I have fixed on the matter and 10:30. How can it?
That matter, Mr. Surajit Mitra, I am also appearing. Bunch of 3 matters. Antara, Mondol, Gargi.
Yes, 3 matters are there. I understand.
So before that,
it was fixed on 10:30.
No, that is fixed on 10:30.
That was the 3 matters are fixed on 10:30.
So kindly take it, my lord, item number 1, 10:30. This one, because this is relating to hearing matter. It will take some time, and this is I am praying for an injunction.
Okay. 10:30. As item number 1. As item number 1.
Much.
Affidavit of service filed on behalf of the petitioner is taken under account. Next. Yes.
My lord, may kindly come to page 17, my lord. I am the agent of Indian Oil Corporation for lifting kerosene and to distribute it among the attack dealers. That is an agreement at page 17.
Yes.
Now, my lord, will kindly come to my paragraphs to understand what I want. That is paragraph 3 at page 3.
Yes.
The petitioners are required to lift kerosene from the terminal point of Indian Oil Corporation at Rajban through their own arrangement. You will also kindly mark own arrangement. And as such, the petitioners are required to give the registration number of a particular tank lorry wherein the kerosene will be loaded by the IOC. The petitioners entered in agreement. I have given that. I am not troubling your lordship. The lordship find at page 27 that the said lorry number, the tank lorry number which are provided by me, that is at page 27, that is the invoice at the top. Here you will see kind by TT number.
TT number.
Yes, tank truck.
Tank truck number.
Number WB 677928.
Yes.
Then my lord, in the course of paragraph 7.1, in the course of business on or about 5th November 2024, the petitioner sent the said tanker to the IOC terminal for loading of kerosene, but the terminal manager of IOC refused to give load in the said tanker, alleging that the said tanker is not being 15 years old. One of the only allegation is that he is 15 years old, that's why we shall not give the load. No, my lord, immediately what I have done, I have sought for the document and I have collected the document that this tanker should kindly come to page 28. It is the motor vehicle department who can certify whether it is a fit or unfit. So this is the certificate of registration. I have nothing to do, my lord. At the top, tanker number is there.
Yes.
Page 29. Certificate of fitness. On the right side, my lord, your lords will find 30 September 2025.
Up to 2nd September 2025.
Next inspection is 2nd September.
Yes.
But it's fit up to 31st October.
Yes.
Then, my lord, next page, that is calibration certificate. That is also till 1st September 2025. Page 30, at the top WB 67 and at the bottom left side, expedition due on 1st September 2025.
Yes.
Then, my lord, kindly see page 31, Transport Department, permit in respect of goods permit, item 7, serial number 7, from 12 November 2024 to 11 November 2029. Then, my lord, next page 32, same thing at serial 7, validity.
Yes.
Page 33, that is insurance. It is till 22nd October 2026, 25, sorry.
25.
My lord. Now, my lord, that is explosive license. Explosive license of this tanker, that is at page 36. It was renewed from time to time. It has again been renewed till 27 December 2024. Page 36.
Yes.
Page 37, tax paid up to 5th February 2025. Page first paragraph, TW welfare says August 24 to 5 February 2025, additional motor vehicle tax up to 5 February 2025.
Yes.
So, in all respect, the tanker is fit. It is the transport department who says the tanker is fit, but Indian Oil Corporation says that I will not give load, but because it is unfit due to 15 years old. There is no such any law that Indian Oil Corporation can make such allegation. Therefore, my lord, I made a representation on 38 and I forwarded all the documents. Page 38. My lord.
Okay.
But still, they are not supplying kerosene to me.
Through this tanker.
To the state tanker. And your lordship knows, my lord, we are required to give this tanker number. Otherwise, if I get the higher tanker, then I will again have to get it registered. And if any contemplation occurs in the product, I will be liable for the same. That's why we take our own tanker. And that is the policy of the IOC, that they want to give load in the tanker of the
Yes.
client.
Yes, what is your view?
My lord, I cannot understand what is the cause of action because it is a mere apprehension, my lord.
No, they have come back.
Is there any termination, my lord?
No,
of the
you are not
contract?
allowing the tanker to lift the
Sir,
kerosene.
where is it, my lord?
Yes, I have said.
He said on the alleged verbal communication, he is saying the petitioner.
They say that it is not.
And even if it,
You accept this, they have
even if it,
submitted
where
an
is the
application.
representation?
Yes.
They have submitted representation.
That is
My lord, kindly see page 38, which my
yes,
learned friend is saying it's a representation.
Request.
He is just giving the documents. Where is the representation that his contract has not been accepted and he is not being given petrol for
My lord, kindly see subject. Request for loading of PDS SKO by tanker number such and such. These documents I am providing. Last paragraph we request.
and even if it, my lord, it's a contract, private contract between the parties, how is section 14 being violated here?
This is for PDS.
There is an arbitration clause in the agreement. This is a private contract only because it's a PSU. Section 14 cannot attract.
you cannot debar any person without any cause.
My lord, where
You
is
have
the
a contract.
where is the debarment, my lord?
There is no contract regarding this.
Then how he appear before this
There is
court?
a contract. My lord, there
For
is a
tanker,
contract.
There is no contract.
Yes.
Agreement says that I will
No,
have to
what are your submission? You are not debarring them.
My lord, where is the debarment?
Then why he approach?
My lord, let him give a representation, then formal, saying that they have been debarred. And there is an arbitration clause. If they are being aggrieved as per the contract, if they are not being given, they are not being allowed for loading, they should abide by the terms and conditions of the contract.
Contract does not say that.
My lord, kindly see the contract.
Yes. Let him place the specific paragraph.
My lord, page 17.
That is an agreement.
As per this agreement, they are being given to
lifting the kerosene.
And there is an arbitration clause to that.
But
Well, kindly come to
there
page
is no
28.
clause of the agreement. That is mere verbal order
Kindly,
of the terminal manager.
kindly see page 28, clause 28. Any dispute or difference of any nature whatsoever, or regarding any right, liability, act, omission on account of any of the parties hereto, arising out of or in relation to this agreement. This is in relation to this agreement which my learned friend is alleging.
So the person has to go to the arbitrator and
there is a provision, my lord.
Yes, they are lingering for 2 years
Yes.
and his business should be suffered.
But I like to.
IOC being a state,
yes,
it will do act arbitrarily.
Well, just because I being a state and coming under Article 12, my lord, and it's a private contract, cannot attract Section 40, Article 14, my lord. To that, my lord, may I be I am placing one judgment, my lord.
When it involves public distribution system, my lord, this is the effect on the beneficiary.
Yeah, however, today the
Yes, my lord.
time is there. So,
my lord, this December is ending. I won't be able to lift the quota of this month. Therefore,
Malik, I'll keep it tomorrow then, my lord.
Yes, time is not
Yes,
there.
yes, not tomorrow, my lord, let it be at
2 PM কি আছে? হ্যাঁ? কালকে বৃহস্পতিবার অরিজিনাল সাইড আছে না? 5টায়? এটা নেওয়া যাবে না? কি আছে লিস্টে? ফার্স্ট কালকে বৃহস্পতিবার তো। গ্রুপ 6 tomorrow is a group 6 matters.
No, today, let it be continued at 2 PM. I said
2 PM, my lord, has
some other matters.
Yes, my lord, I have also got matter at 2 PM. But that it will take only 5-10 minutes, my lord. Let it continue.
Now come on Monday then.
My lord.
Monday it will be next month, my lord. Then this month quota will go.
Then I have to heard on tomorrow then. Tomorrow, fix it at tomorrow. Yes.
My lord, tomorrow?
Tomorrow.
Tomorrow.
It will be second matter.
In the second half.
Second matter.
My lord.
Second matter.
Second matter. My lord. My lord, item number 20, 21, 22 are all similar matters.
Three are same, my lord.
All similar matters.
Similar matter.
20, 21, 22.
All three are.
All three will appear tomorrow.
My lord.
Yes.
Praying for unconditional apology that 3 p.m. matter. I have informed my London senior, Mr. Sahara. That's it. Today, also I'm excused. Also kindly not this.
3 p.m. matter, which matter?
One
Item number?
matter.
Okay, you do not available in this matter.
Possible, I have requested my London senior, Mr. Sahara. Possible, kindly next Wednesday.
Very.
No order. That's all. That's what happened.
Call the list.
Item number 2.
My lord,
I am appearing for the university grant.
my lord,
Yes.
My lord, I am for the petitioner.
My lord, in that event, my lord, kindly, my lord, make it, my lord, 1 week accommodation may kindly be given, my lord. We,
You are appearing on behalf of whom?
I am for the state, my lord.
For the state.
State, my lord. And on earlier occasion, my lord, we informed that our affidavit in opposition is in the record, my lord. And
Yes, it is in the record.
yes.
Affidavit is there.
My lord, kindly adjourn for a week, my lord. Instead
Okay.
of Passover, my lord, kindly adjourn for a week.
Next week.
Next week, my lord.
Next week.
I'm good.
Affidavit opposition we have filed a long ago, but no reply has been given by the petitioner.
None.
They would not use any reply.
She has not that petition should be dismissed, madam. My principal prayer is against the authority, madam.
And-
Saying that UGC pay scale should be implemented. But possibly UGC has not said anything contrary to my prayer.
Let's start on the next week.
Yes.
Okay, it is already parted. I'm running in the list with these matters. I don't have the determination now. Only parted matters are there. Assigned matter. I understand. One accommodation is sought for in the first sitting.
Achha,
All parties are here.
Hey, give me item number 1. Give me item number 1.
Item number 2, my lord, kindly record one line order.
Yes, I shall record all the orders.
Two.
Very well. Give me first item number 1.
Item number 2, my lord.
Respondent number 6 and 7.
6 and 7.
Respondent number 6 and 7. Represented by learned counsel Mr. Chakraborty.
I am my lord Anish Kumar Mukherjee.
Anish Kumar Mukherjee. Learned represented by Mr. Anish Kumar Mukherjee submits that senior advocate Mr. Billadul Bhattacharjee is not available today. So is 6 accommodation. The matter be adjourned today. List the matter next week. I said next week. That is on next week. 4th at 2 p.m. Okay. 4th. You are next now. 4th at 2 p.m.
Submission with respect to the petitioner matter and also my lord I think the university. All of these are my lord already complete.
Yes, only college authority is there. College authority is there. Thereafter your reply.
The university has not yet initiated.
Because on the other day, when my college was not present at the first, my lord decided to submit on behalf of university. At that juncture, the advocate for college came. So my lord said, let college come first because they are the vital
In that way,
response.
my lord, I will be filing one written notes that I will be doing after hearing their.
Let them complete the argument. I hear your reply on that point. Thereafter you can submit the. Then on the next Wednesday it can be done.
It can be concluded, my lord, because this has been my lord pending.
Yes.
for a long time. She has been my lord without the.
Very.
My lord.
Great.
My lord, the lordship.
Take item number 2. An accommodation is sought for on behalf of the petitioner. This is a pattern matter.
Yes.
The UGC as well as the other respondent authority are duly represented.
Yes.
Let the matter be adjourned today. List the matter on 4th of December 2024 under the same heading at 2 p.m.
Yes. Obliged to Lord.
Item number 3.
Yes, Lordship. I'm appearing on behalf of the state respondent, Lordship. I'm being led by Mr. Shumon Chengupta, Lordship. In the last occasion, I think my learned seniors have. तुम्हारा petition है ना? जीवन प्रश्न.
In the
Petitioner is
order of termination.
Yes, yes, Lordship. Because there were series of complaints against the dealer. Initially, it was terminated. Then again, some fine was imposed and his license was again handed over. He was running the shop. Then again, subsequent mass petition against him, and this time it was terminated. But I think the petitioners are not present today. No.
Yes, Mr. Bose?
No.
I had one matter with the college.
Yes, it was urgent.
Urgent.
Next week.
বিলেরা ছিল তো বিলেরা
It was item number 2, your matter. Item number 2, your junior came and it seek urgent.
Sorry. Bibliography.
Your Lordship, I'm on behalf of the petitioner, Your Lordship.
Yes, today is fixed for argument on behalf of the state authority.
Yes, Lordship. So, Lordship, we have not filed any affidavit. We are proceeding on the basis of the report which we have filed, Lordship. So, the report what I have received, Lordship, since we were not a part of this writ petition when the matter was filed, I find that, Lordship, there has been a gross negligence on behalf of the dealer. The boards, when there was a mass application, we received the complaint. Immediately, inspection was conducted, and it was found that the board of the ration shop, the register, the cash book, nothing was in its place.
Yes.
So the explanation, the dealer said that we gave him a chance of, we issued a show cause notice, gave him a hearing also. The reply said that there was a ransack in his shop room. That's why everything got lost. But although it was ransacked, he was running the shop without giving us any intimation also that it was ransacked and there was no cash register, nothing. He had nothing. Subsequently, we dealt with that issue, pardon me, Lordship, gave him a hearing, and upon imposing a fine of 30,000, again his dealership was given back to him, reissued to him. Then subsequent to this issue, again in 2018, sometimes in 2018, we received another mass complaint against this dealer regarding misbehavior this time, Lordship.
Okay.
So now he has come before this honorable court. We gave him a chance of hearing also, but now he has come before this honorable court with the grievance that he has never received the copy of the mass complaint on the basis of which we have acted on. Lordship, as on date, I do not have the copy of this mass application, but what I was just suggesting, this is just my thinking, Lordship. If Lordship can kindly direct the authorities to give him another hearing and supply him the copy of the mass application, then if the dispute doesn't get sorted out, then he has got the chance to come before Lordship.
Only issue is there. Second appellate authority has directed to cause inquiry and report.
Yes.
The inquiry was done.
Yes.
On 14th of January 2020.
Yes, that is the thing. They are of the view that since from our part,
Such report was not handed
handed
over.
over because the COVID period
Hearing
started.
was conducted. This is the violation of natural justice they challenge here.
Yes, Lordship. That is what I am praying before Lordship. If another chance of hearing can be given to the petitioner, and this time we'll provide the copy of this mass petition also, then if the dispute doesn't get resolved there, he has always, the door is always open for him. But this is not due to the negligence on the part of the department. This is purely because of the lockdown. Lordship will find that when this order was passed, immediately thereafter the lockdown period started.
What is the impugned order? Yes, it is the submission on behalf of the authority that the authority may be directed to again rehear the matter. By supplying the all copies you are not handed over.
Your Lordship can pass this.
But what about the license which was terminated?
That has to be set aside. Otherwise, what hearing they will do?
Lordship, since if this process can be completed within a short period of time, then it can be, because
they have challenged the
cancellation. I understand, but
cancellation and the imposition of the punishment also.
Yes,
Such
Lordship.
punishment cannot be imposed.
But the primary ground of this is because of violation of natural justice. What they have stated in their
The ground that the even termination is the capital punishment.
Yes, termination cannot be done.
And your Lordship will find in similar case, Justice Vivek Chaudhary has passed an order that any penalty can be imposed, but other than termination, because this cannot.
Now, these are the complaint of the beneficiaries against you.
Yes.
Yes, there has
Yes,
been.
yes.
Gross
That has not
complaint
been-
against you.
My lord,
For
what is
misbehavior, not supply of the articles.
Missing cash register, details of the board, signboards were not there. There were other allegations also.
these are technical issues, my lord. I will not share everything because this is after the question of fact. But these are technical issues. In the control order, your Lordship has seen that the punishment should be given according to the gravity of offense.
Yes.
So where is the gravity of offense that it should be terminated? My lord, kindly see this. See, in the similar case, the Lordship has directed by remanding back.
একটু WP নাম্বারটা জাস্ট পেলে আমি বলে দিচ্ছি। Rahman.
Probably the statement I have already submitted for Lordship at the time of my submission.
Yes.
That the punishment should be proportional to the charges according to the gravity of offense. Termination is the highest punishment. Penalty of other punishment should be imposed.
Termination disappropriate. Disproportionate.
The Lordship may remand the matter But setting aside this order and with the because the allegations of 100% payment.
Because Lordship, only one thing, Lordship, even if Lordship stays this order, this se-
Stage or crossing. Because the face order whenever you pass, this order will go.
yes, but I don't know the vacancy, it has already
Not
been
vacancy.
filled up or not, I don't
It is
know.
an
na.
order of not declaring vacancy. No, no.
No, no, time frame করে দেবে তো, because that is what I am also saying. Time frame করে দিলে। Then Lordship kindly keeps it tomorrow. I'm being led by Mr. Shumon Sengupta. Lordship, let him come tomorrow and Lordship, he can make better submissions. That's my.
You are competent enough to make submission.
Yeah. I know her, my lord, that probably Mr. Suman Sengupta will not be able to come tomorrow even.
No, no, he'll come.
I know.
He'll come.
I know him very well.
No, no, no. আরে স্যার ওই সব আরজি কর ম্যাটারস
আমি
গুলো
জানি,
পুরো লাইন দিয়ে
এটা
এখন
পুরো কল্যাণ
17 নম্বর, হ্যাঁ 17 নম্বর কোর্টে
telling that
he's just stuck
he will not
there.
come.
আমার আরো প্রবলেম হচ্ছে কি জানেন, একটা ডকুমেন্ট, আমার সব ডকুমেন্ট গুলি ইলেজিবল পড়াই যাচ্ছে না। এখানে আপনার থেকে জেরক্স থেকে জেরক্স করেছে না, see my documents. I couldn't even go through the documents. It's so illegible. I don't. This is a photocopy which I have made. This is the report which we have filed. Mane they have no. The difficulty is that I was not there in the brief. It is a photocopy from your set. only. Photocopy from your set.
Hmm.
এমনি তো টার্মিনেট করাই যায়, তো যতদিন না হিয়ারিং হচ্ছে ততদিন করে দিই।
কতদিন চালু করবে?
তো যতদিন আমি
Yes.
within a short.
My Julia wants to place, asking me to place. That is second appellate authority denied supply report and to
Yes.
or to examine the party. So my lord, on the basis of 100% payment, the judgment which I have cited already delivered by Justice Samapit Chatterjee, that on this score alone, the order is liable to be certified.
সেটা আবার কোনটা?
100%?
100% payment of all the quantities is
Okay.
required to be done. I have shown your lordship my paragraph and the judgment I have already cited to your lordship. 2016 SCC online Calcutta 1247, wherein the allegation of shortage in stock was set aside. 2016. I will kindly come to paragraph 22. Considering the submission, the lordship reading manner.
Yes.
Distributors shall render all facilities for physical verification of stock under PDS on demand by the instrument, but in the present case, the state officer did not demand any facilities for physical verification of stock. On the contrary, it is evident the officer chose to record the stock on an estimation basis, which is not at all permissible under the law. It is also evident from the record the allegation in the stock is contrary to the sheet prepared the spot. And so I also find substance the submission of Mr. Bandopadhyay that the so-called notice was based on the counting of food gain. I cannot ignore the provision contemplated in the paragraph 30 of control order, which interior mandates that authorities would prepare payment chart and chart of physical verification stock, which is completely lacking in the present case. It is admitted fact that in the state physical verification report appears for XLR1 does not bear any signature of petition. I also cannot shut my eyes on the argument demonstrated by Mr. Mundar that the inspector may reach that the petitioner could not. That's matter is not considered. Conceding there was, I have no hesitation to hold that the impugned order cannot sustain in the facts and circumstances of the case. According impugned order is set aside, first and set aside. Therefore, all the document I may report was disclosed, so-called notice, all set aside.
Lordship, according to my understanding, this judgment is not applicable in this case, Lordship. Here the stocks were verified, Lordship. What I find from the report also, in page 24 of the report, although my copy is clearly not illegible, but it shows that they have done their inquiry properly, and all the details have been specifically mentioned here. If Lordship kindly comes to even page 4 of the report, which has been filed on behalf of the state, clause 3. So there was a direction of inquiry, and upon inquiry, it was found that it is stated that the area inspector Shantipur submitted an inquiry report dated 23/11/2017, wherein various anomalies.
You are
were
reading paragraph?
Page 4, clause 3.
Of a
Report.
Yes.
3, which states that it is stated that the area inspector Shantipur submitted an inquiry report dated 23/11/2017, wherein various anomalies are stated, such as signboard are not found, no cash book or register was found. A copy of the inspection report is annexed here to and marked as an R3. This is at page 24, Lordship.
It is their preparation. It is not signed by the petitioner.
Obviously,
Then,
he
my lord,
refused
second
to
page.
sign.
The case was, my lord, right to page 25. Rice 153 bags full, 10 quintals from scattered on the floor. So 100% payment of 153 bags were not done.
Lordship, if Lordship kindly comes to page 25 of this report,
Yes.
page 25, Lordship.
Please. 25 of the report.
He দেখাচ্ছে।
153 bags.
He is saying
the
that
payment chart.
his client has not signed it,
No,
but
no.
Lordship will find that the client has obviously
And on the page
the
25.
signature is there. At page 25, the signature is there.
That is different page.
Page 25. This is the continuation of the report. Yes, assessment of the stock position.
Assessment has been done on the basis of
This is
counting
the
of bags.
continuation. Lordship will find from 24 it has
Dealer was not present at the time of inspection, and his
His representative namely
has been done in my the whole inspection has been done in my presence.
Jibon Poddar could not provide
Right.
labor for necessary for
physical verification
measuring the
of stock has
stock.
not been done. Physical verification of stock has not been done.
Done now.
So physical stock was not done, but allegation of shortage was there.
However, if there is a shortage, there may be some punishment of cash punishment. Fine.
That has been imposed, Lordship. Fine.
License was terminated, I think.
And the petition suffering from 17. Already 7 years has left. Sufferance is enough. Enough sufferance. A physical handicap dealer is suffering for 7 years for his subsistence.
Lordship, I think there must be some writing mistake, because if Lordship kindly sees, the two statements are actually not tallying. The FPS dealer was not present, what my learned senior friend was showing
Yes,
at
page
page
25.
25. But here, when it is written, it is written that the whole inspection has been done in my presence and the fact is true.
This is not Jivan Poddar.
Whose signature is this then?
Jitin Poddar.
Who is this?
Jitin Poddar.
Who is this?
His representative.
Jiten Poddar is one of the representative of the
Not
Jivan
petition.
Krishna Poddar.
His representative is there.
Yes,
His
it
representative
was
is
written there by the officer.
Yes, and that is admitted. But it is also admitted that these bags were not 100% made payment.
Hmm.
Okay, hard.
But
Yes. Yes.
and he পড়বো কিছুই করা যাচ্ছে না মানে how I am doing no matter I only know.
Impugned order dated 25th of November.
Impugned order dated
25th of November 2020.
18.
25 November 2020.
20.
2020.
2020.
That is the last order.
That is the last.
Appellate authority, second appellate authority order.
2020. 78 page.
21.
First
Oh,
appellate authority's order is 26th of June 2018.
First order is my lord.
The only difficulty, Lordship, in my copy is like this. So I don't have anything. It's a court appointed matter and we stepped in so late and I do not have the instructions even. This is the instruction which is illegible. The copy which I have received from
You
my...
have handed over a good copy to me.
No, this is the copy which has been handed over by my lord.
This is third copy. First copy, second copy, Mr. Suman Sengupta, third copy to her junior, to his junior.
No, I have not. This is his copy only. I do not have any copy.
I have seen that copy.
This is his copy only.
Whatever. First appellate. SCFS terminated order was 15 January 2018. And first appellate authority order was
First appellate authority termination order district controller 10/5/18.
10th May 2018.
10/5/18.
And second appellate authority order was
26/6/18.
No.
আমি যেটুকু সামনেটা তো করতে পেরেছি অ্যানেক্সটা তো কিছুই করতে পারিনি
Now, what is the impugned order 25th of November?
Yes, because first time it was terminated, then again it was cancelled and fine was imposed.
That
Yes.
is first.
That is the first round.
No, that was first round of
Yes.
first.
Then the second round started for another mass
Well,
petition. Then this time is the wherein he has not
This is
received
10th
this.
December 2018, first order. Page 60 of the report.
Page 60.
60.
Yes.
And second order, that is the first appellate authority, 28 November 2019. That is at page 65. Upholding the order of the termination.
This is the first appellate authority.
Yes.
Yes.
And second appellate authority is last one. That is at page 78.
এগুলো যে কি আছে ভগবানই জানে। এই জানি না তো। I don't have any clue.
আমার তো clear হচ্ছে না। Mr. Flood ভাই।
My predecessor.
আজ প্রচুর message চালায়। Weekend. এখন বৃষ্টি চালায় থাকছে। Weekend. And weekend.
আমি তো কিভাবে পড়েছি আমি জানি this petition. I don't have Spanish. Sir. So I thought
Okay, please take down.
I tried my best. I cannot get it. এটা চলে যাচ্ছে চলে যাচ্ছে আর শোনাবে কি দাঁড়াবে আমি একদিন বলবো
What are the facts of the case? I am narrated in a note. If your lordship wants.
Yes, I got it.
No, that copy of the notes, man.
This is the list update.
List of this and that notes.
You have given the notes.
No, I am
I have
handing
two.
it over now.
Okay, I have two list updates.
Earlier, list update was given to Justice Patnaik. Then, my lord, this list update was given to your lordship. Same thing, my lord. That is chronically.
No, previous matter is not the issue in this
No,
matter.
previous matter is
No,
not
no.
the- Previous matter is not the issue.
Not the issue here.
Because this is a fresh cause of action because fresh notice,
Yes.
fresh mass petition was been given.
Fresh.
Here the point was of for natural justice because the
Yes.
copy of that mass petition was not handed
Not
over.
handed over to him. The present petitioner is an FPS dealer. At PS Santipur district, Nodia. Full stop. He challenged an order of Director DDPNS dated 25/11/2020, whereby thereby the Director DDPS, being the second appellate authority, has affirmed the order of termination of concerned SCFS dated 16th of December 2018, duly affirmed by the first appellate authority on 28th of November 2019. Full stop. The brief fact of the case is that a team of officials headed by concerned SCFS Nodia conducted an inquiry at the fair price shop of the appellant on fair price shop of the petitioner on 27th of September 2018. After receiving a mass complaint from the beneficiaries with the allegation that the present petitioner is a man of bad behavior, poor service, keeping of entitlement by misguiding the beneficiaries. Full stop. During the inquiry, several discrepancies were found in the FPS shop. The inspection team has noted in their report that they have found some shortage in the PDS article, comma, the list of Annapurna list was not displayed. Ration card register was not found in the shop, comma. Inspection book and complaint book was also not found, etc. Full stop. During hearing conducted by the concerned SCFS, the petitioner has denied all the allegations regarding his misconduct upon the beneficiary. He also challenged the inspection report regarding the misappropriation of stock of food grains. The DCFNS Nodia at the time of hearing was not satisfied about the report and again directed the SCFS Ranaghat to cause an inquiry regarding the authenticity of the mass petition against the petitioner. The report was submitted and the petitioner was again heard. At the time of hearing, the petitioner also placed a document containing some list of beneficiaries who signed in favor of the petitioner. The appellate authority has passed an interim order directing the DCFNS Nodia to probe the actual situation and the appellant was directed in the second hearing to submit the detailed report within 7 days. Next para. The DCFS Nodia has submitted a report containing inter alia that the beneficiaries were interrogated and they have disclosed that the appellant had a habit of misconducting with the beneficiaries attached to his shop. They have also alleged that the petitioner did not distribute food grains to the consumers in the proper scale allotted by the concerned department. During the course of hearing by the second appellate authority, by the director DDPNS, Director DDPS, being the second appellate authority, has taken note of the fact that on the earlier occasion, the license of the petitioner was terminated. Almost similar charges. the concerned authority, concerned second appellate authority, find it appropriate to uphold the decision of the SCFS Ranaghat, who terminated the a piece of license owned by the present petitioner. Full stop. Mr. Agarwal, learned counsel appearing on behalf of the petitioner, submits that the impugned order passed by the second appellate authority suffers illegality. The inspection the report of inspection was not at all handed over to the petitioner prior to the hearing. No meaningful opportunity of hearing has been awarded to the petitioner, as he was not handed over the allegation raised against him. He further argued that allegation of shortage of stocks was not properly measured. It was only made by eye estimation. Full stop. Mr. Agarwal has pointed out the relevant pages of the report of the authority concerned, wherein it has been specifically noted that the shortage of articles was not measured physically. He further argued that the termination of license is the highest punishment. The said punishment cannot be awarded only on the basis of some alleged complaint by the beneficiaries. He submits that the punishment is disproportionate. Learned counsel appearing on behalf of the state authority has submitted that the present petitioner is not a person to be allowed to hold a license to distribute the food grain to the beneficiaries. It has been proved before the authority concerned that petitioner behaved badly with the beneficiaries in distributing the ration articles. It is the specific submission of the state authority that if the petitioner was allowed again to distribute the ration articles, the same situation would be occurred. He further submits that the present petitioner is a habitual defaulter, so he cannot be allowed. He is a habitual defaulter, so he cannot be allowed to continue with the license. Are the learned counsels? It appears that the team of officials headed by the concerned SCFS Nodia has conducted an inquiry at FP shop of the appellant on 27th of September 2018. Full stop. The inquiry report was placed by the authority concerned along with the report. On perusing the said inspection report, it appears that the petitioner was not present at the APS at the time of inspection. Only one of his representative, namely Jiten Poddar was present. It has been mentioned in the report itself that as the representative could not provide the labor, so the stocks, so the physical measurement stroke verification of the stocks was not done. The report also pointed out the shortage of stocks in kgs. So it can be said that the concerned inspecting officers has measured the weight of the articles through eye measurement by the calculation by counting the bags only. Full stop.
The second inspection is at page 47.
Page 47.
47. Second inspection. And this time the allegations are been specified at page 49.
Yes.
Although my copy is not really very legible, but
It further appears from the inspection report that the inspecting team has noted down several discrepancies regarding the displaying of list as well as the maintaining proper books according to the provisions of the control order. It appears that the second appellate authority has noted down several report which was received by the first appellate authority during inquiry, during hearing. It has not noted in the impugned order that the report during the hearing, a report which was submitted by the concerned SCFS Ranaghat was at all handed over to the petitioner. It further appears that the inquiry report of DCF and S Nodia in pursuance to order dated 14/1/2022.
Lordship, only one interruption. Lordship, kindly comes to page 52 once, although my copy is not really very legible. 52.
52
of
yes.
the report.
No, this is dated 27/9/2018.
18.
That is the inspection report. Afterwards, it was given to the Jivan Krishna Poddar.
Yes.
He received it. The inspection
the
report, handed over to him.
Yes, inspection report was handed over.
Handed over to him. Inspection report held on 27/9.
Inspection was also held on 27/9.
27/9.
And
Thereafter, during the hearing of the first appellate authority, 2 inspection was done.
yes.
2 inspection regarding the allegation of the beneficiaries. That was not handed over. Bias was not handed over to the petition. It is true that the present petitioner was earlier punished by the concerned authority on the similar charges. But the finding of the concerned second appellate authority cannot be accepted as because because the petitioner has earlier punished with the same cause. I make it clear that the the director DDPNS being the second appellate authority must have hand over the inquiry report of DCF and S. Nodia before conduction of hearing of the second appeal. However, the measurement was not done properly. However, admittedly, the measurement was not done properly regarding the shortage of PDS at the FPS shop of the petitioner, fair price shop of the petitioner. Considering the entire aspect, I am of view that the punishment as imposed upon by the petitioner, punishment of the termination of the license as imposed upon by the petitioner by the concerned authority is disproportionate. Full stop. Under the above observation, the concerned second appellate authority, director DDPNS, is directed to rehear the matter after supplying all the necessary documents and inquiry report to the petitioner, and shall dispose of the hearing by passing a written order within 6 weeks from the date of passing of this order. Under the above observation, the under the above circumstances, as the punishment, as the order of termination appears to be disproportionate, so I think it necessary to set aside the order of termination. In the meantime, till the written order be passed, the petitioner may be allowed to continue with the license. Disposed of.
May I make a submission? Since the director has earlier passed the order, let it be remanded back to the secretary. Otherwise, my lord, your lordship knows, I recall once Justice Dias was in the division bench, and while restoring the matter, he asked me whether the same judge is in the same bench. No matter that now. Then I am remanding back.
Remand means by the same authority. Remand means by the same authority.
Same, my lord.
There may be new person there. Right now.
Obliged, my lord.
I am waiting for respondent who want to speak.
My lord, I
I'm for the
brief. My lord, this matter, lordship may recall, my lord, Mr. Torokdar was submitting, my lord, he is just on his way. But before that, my lord, I'll just recapitulate, my lord, this is, my lord, with regard to, my lord, imposition of penalty, my lord, upon the petitioner, my lord, by the West Bengal Essential Commodity Supply Corporation Limited. My lord, on the, my lord, primarily two grounds.
Yes.
My lord, the first ground, my lord, was, my lord, the allegation that, my lord, the sugar that was supplied under the, my lord, we were successful bidders in the tender. My lord, Mr. Torokdar, and I am led by Mr.
Yes.
Let's recapitulate facts. Just
একেবারে
Yes. Yes. On the last occasions, my lord, I addressed my lords on the issue of maintainability of the writ petitions, my lord, on the ground of availability of alternative remedy. Then thereafter, I entered into the merit of the case, my lord. I placed the entire tender notifications, my lord, containing all the clauses, particularly relating to specifications of the sugar. Then thereafter, my lord, I placed the placement order, my lord. Pursuant to the order of placement, my lord, supply order, my lord, petitioner started supply, my lord, to all the, my lord, areas as, my lord, specified in the order of supply, my lord. Thereafter, my lord, in this background, my lord, on after supplying the sugar, my lord, on 12th October 2018, my lord, relating to the supply given by the petitioners, my lord, from the Dankuni storage, my lord, a show cause notice was issued, my lord, to the petitioner at page 96, my lord. Yes. Regarding show cause for rejections of sugar sample and rebuild up sugar stock of Dankuni Godown. With reference to the above subject, this is to inform you that as per report of the Directorate of Inspections and Quality Control, Food and Supply Department, Bite number so dated 12th October 2018, a sugar sample which collected Bite sample number 144 dated 11th October 2018 from sugar godown at BD Casting, Dankuni, Hooghly has been rejected for excess moisture. Hence, you are hereby instructed to replace the substandard sugar stock already built up at above said sugar godown immediately as per quality assurance clause of tender conditions, copy enclosed. You are also hereby directed to show cause why penalty should not be imposed for storing of substandard stock of sugar at godown, which has resulted in interruption in supply of sugar of Puja Festive Package 2018 through PDS. This reply must reach this office by 13 October 2018. So, my lord, I pause for a moment, my lord. This so-called notice itself shows, my lord, how, my lord, the concerned authorities acted in a unreasonable manner. This so-called notice was issued on 12th October 2018, and the petitioner was directed to reply, my lord, by 13th October 2018, not even one day. So it's absolutely hot haste, my lord. And the Supreme Court has held, my lord, well, there is a hot haste, my lord, it presumed to be malafide. Then, my lord, I'll invite your attention in the second paragraph. Hence, you are hereby instructed to replace the substandard sugar stock already built up. So, therefore, substandard sugar stock has already been held. So, this is absolutely prejudged, my lord. So, there is no scope to reply even show cause notice. Prior to that, they came to a decision that the sugar is substandard, and only one day time was given to give reply. So, whole actions is absolutely arbitrarily and unreasonable. My learned friend pointed out on the last occasions that my lord, one of the ground, my lords, I may not canvass before your lordship, my lord, regarding the maintainability of the writ petitions, my lord, because of the violations of fundamental right, my lord. So, here, my lord, the actions taken by the concerned authorities shows how unreasonably they have acted, my lord. The requirement of Article 14 of the Constitution is duty to act fairly, reasonably, bona fide, and with a sense of responsibility. So, this is the way how they have acted. Then, my lord, then two documents annexed with the show cause notice. My lord, the part of the, my lord, tender notifications disclosing quality assurance that we have already placed before your lordship. Then, my lord, the analysis report at page 98. This analysis report, my lord, I will draw your kind attention, my lord, only two aspects, my lord. That the Bengal Agency BD Casting sample drawn from Bengal Agency BD Casting 51 number bus stand Dankuni Hooghly. Then, my lord, fourth column lab sample number 144, number of bags 57340 bags. Moisture contents 0.14, 0.17, 0.21. So it is surprising, my lord, how, my lord, on the same sugar sample having a different reading, my lord. Suppose, my lord, if the moisture content, if it is tested, my lord, it will be found, my lord, either 0.14 or 0.17 or 0.21. At the same time, how three readings could be possible, my lord? So, however, this report was, my lord, annexed with the show cause notice, my lord. Then reply was given at page 99. With reference to the receipt of your letter dated 12th October 2018 regarding show cause notice,
Yes.
notice regarding show cause notice of sugar stock at Dankuni Godown, we assure you, sir, that the sugar stored in the above godown is among one of the best available S30 grade sugar available in India, which is very much relevant from the document, from the supply. Sir, we have participated in the tender to serve West Bengal Essential Commodity Supply Corporation Limited with full honesty and integrity. Moreover, the tender stipulation for quality of sugar is giving both for ISS specification, Bureau of India standard. We got inspected, we got inspected in the year 1986 for all manufacturing items in India, and Food Safety Standard Authority of India came in the year 2006 for the primary objective of setting standards for food, so that there is one body to deal with and no confusion in the minds of the consumers, traders, manufacturers, and investors, and thus superseding any law or standard for food products. The moisture contents permissible as per FSSAI specification and our Bureau of Indian standard is not required. FSSAI Act has come into force. Even obtaining certificate from food specification Bureau of Indian standard is not required for food related organization. Sir, even in the report, there is wide variation of 0.07 in the result of same sugar sample, higher side being 0.21, lower side being 0.40. Since the sampling of sugar was done in the late evening, and especially the whole area is affected under cyclonic rain, there may be some human error. We assure your good self that the whole sugar stock free flowing and dry. Moreover, we have taken coercive measure for resampling as taken in the instance. Hope your good self will kind enough to give a chance to serve WBSCC arrange for resampling in the eye of doing natural justice to the whole matter, as your good self have always been. Hence, we are requested, hence we requested from any penalty, not credible. Said the resampled sugar at Jalpaiguri and Darjeeling have already passed as per your requirement, and we inspected the respective district controller. We are completely satisfied, who were completely satisfied with the quality. Sir, assuring best of our service at all time and apologize so and so. Then, my lord, with this reply, my lord, petitioner also annexed, my lord, the relevant extract, my lord, from the Food Safety and Standard Act at page 101A. That is regulation 5.7.2 sugar. Plantation white sugar, known as sugar, means the crystallized product obtained from sugarcane or sugar beet. It shall be free from dint, filth from fillings, and added coloring matter. Extraneous matter shall not exceed 0.1% by weight. It shall also conform to the following standards, namely, moisture contents that is not more than 0.5% by weight. So
there is a typing error. It is 5.5.
yes, but
page 100.
Yes, page 101. Page 101, my lord. That is, it is not legible because of the type copy. This is 0.5. 0.5%.
Not exceed 0.5%.
Yes.
Not 0.1%.
It would be 0.5. In the type copy, there is a mistake. I will show you from
Yes,
the
yes.
Act, my lord, itself, my lord, that this is the standard, my lord. That apart, my lord, I will take your lordship's, my lord, page 102, my lord. Sorry. Then, my lord, 132, 1 minute, my lord, 36, 37. At page 32, my lord, I'll take you, my lord. This sugar sample was resampled, my lord, 132.
Resampling was done.
Was done, and it was found well within the parameter 0.10.
0.1.
0.10. That is the exact requirement under the tender documents, my lord. So,
when the resampling was done?
my lord, resampling was done, my lord, 31st October 2018. That is analytical report of sugar resampling, 31st October 2018. And upon sampling, my lord, upon found, my lord, that it is well within the specification, supply was made, my lord, and it was reached to the consumer, my lord, and the end user has already consumed that particular sugar, my lord. So, even, my lord, the penalty was issued, my lord, to the petitioner for failure the standard of the sugar, my lord. So that I will take, my lord, from the I will take you to your lordship, my lord, to the respective penalty, my lord's notices, my lord. Then, my lord, and this is about twofold, because this particular show cause is bad on two count. Number one, that this was well within the parameter prescribed by the Food Safety Standard Act, that is 0.5, but in the contract that was provided as 0.1. 10. So, my lord, if my lord, then my lord, if my lord, this is a contract, my lord, by and between the parties, my lord. If something provided in the contract and if something provided in the statute, my lord, then statute will prevail over the contract, my lord.
If there is a difference between
Yes,
the contract and the statute,
and the statute,
the
my lord.
statute will prevail.
Yes, that will show the judgment to your lordship, my lord, on this. Just, my lord, because this is one of the instances, my lord, there are many instances. Then, my lord, I take your lordship, my lord, to page 102. December 2018.
Yes.
Another show cause, quality failure of sugar, Murshidabad district. That was Hooghly district, my lord, and this is relating to Murshidabad district. With reference to the above, you are hereby informed that the stock built up by you of 1398 quality at Narendrapur, Narendra Kumar Jain Godown, 45 SN Bakchi Lane, Post Office, Khagra, Murshidabad district has failed the quality assurance test sugar as per the quality control report received from the Directorate of Inspections and Quality Control, Department of Food and Supplies, Government of West Bengal. Hence, you are hereby requested to take necessary measure regarding the same and also intimate the corporation regarding those measures taken from you from the from your end and duly countersigned by district manager under WBSC Limited of the aforesaid district, my lord. Then, my lord, along with this show cause, my lord, the analytic report was annexed, my lord, at page 103.
Yes.
Then Bengal Agency, Narendra Kumar Godown, Narendra Kumar Jain Godown, 45 Bagji Lane, Khagra, Murshidabad. Appearance is 31 grade sugar. Then remarks. The said stock against the lab sample number 166 does not conform to the specification of S30 sugar as per IS 5982.003. I invite your lordship's attention, my lords, for a moment to the requirement mentioned in the tender clause as page 64. At page 64.
Yes.
Grade. The grade of sugar to be supplied should be S30 or higher variety as would be intended by the government. So S31 is Milord higher variety of S30. So this was well within the specification. Still, Milord, the show cause was issued, Milord.
So S31 is the superior quality than S30.
S30. That I will show you, Milord. From the report, Milord, it would be apparent, Milord. I will also take your lordship to the report. Then, Milord, on receipt of the show cause, petitioners gave reply at page 104, Milord.
Yes.
Then, Milord, in the reply, Milord, then the analysis report, Milord, resample analysis report was annexed at page 104A.
Yes.
Bengal Agency, Narendra Kumar Godown, 45 SN Bagji Lane, Post Office Khagra, Murshidabad. Date of receipts, 21st December 2018. Quantity involved 1398, so and so. Appearance S30 grade sugar. Then remarks. S31
grade
S31. Then remarks. The said stock against the lab sample conforms to the specification of plantation white sugar as per so and so. The sample conforms to S31 grade sugar. S31 grade sugar is better than S30. So still, Milord, I have been, Milord, issued penalty, Milord. So this is, Milord, these actions are wholly unreasonable and arbitrary and whimsical, Milord. This is contrary to violative of Article 14, Milord. Then, Milord, I take your lordship, Milord, to page 133. Because there are 4 analytical reports, Milord, in respect of other godowns, Milord. Page 133. Rather 133A, because it is legible copy.
One 33A.
33A. Bengal Agency, Agarwala Price Mill, Barwan.
Yes.
Yes. Then lab sample number 132, quantity involved 5931. Moisture content 0.12. Your lordships have got it?
Yes.
0.12. Then it was again resampled, my lord. Next page, at page 134.
Moisture content 0.1.
0.1. Then this was supplied, consumed by the end user. Then, my lord, page 135A.
Now, why once a report is appearing, the major moisture content more and thereafter less?
Because that is why, my lord. That is why this was done, my lord. That, my lord, I will argue before your lordship why it happened, my lord. Because, my lord, how the sample will be taken, my lord, and how it could be examined, how it could be tested, my lord, and who will be tested, my lord, everything has been prescribed under the statute, my lord. But this was not done, my lord, in accordance with the provisions of the statute. They have done on their own way. And, my lord, we, my lord, sought for informations by filing an application under the Right to Information Act. They categorically admitted, my lord, their laboratory is neither calibrated, neither they have the requisite qualifications as per the standard specified in the FSSI Act. Everything was admitted, gave reply, my lord, to the queries raised by the petitioners, my lord. So, my lord, unless, my lord, that the sample, my lord, is to be drawn up and tested.
What happened? Show cause was issued.
Yes.
And you replied the show cause.
Yes.
And again verified.
Oh, no, we requested for resampling.
Resampling.
Right.
Resampling was done.
Was done and found that it is well within
the specification.
Within the specification. Supplied, and that was
So show cause withdrawn.
Yes, my lord. No, withdrawn. Penalty was imposed. That's my, my lord, before your lordship, my lord, forced me to come
all
before your
time when Sokoj was executed, penalty was imposed.
Yes, my lord, that's the case. That is arbitrary, my lord. And the entire actions, my lord, because tender notification says that standard, my lord, specification standard would be as per FSSI Act or Bureau of Indian Standard. So they have replied to the queries, to the question short for, reply short for on the questions raised by the petitioners in the RTI applications, that whether that these specifications as per under the FSSI standard or BSI standard. They replied, no, it is as per their own standard. That is not permissible under the statute.
No,
So this is absolutely
tender agreement also FSSI.
Yes, my lord, FSSI or BSI. And everywhere, because this is governed by the Food Safety Standard Act. Once the Food Safety Standard Act came into force, my lord, then everything will be guided by that.
Yes.
No one can act according to their own sweet will. So the Rules Regulations Act, my lord, has been framed, my lord, to limit the power of the authorities, my lord, in a manner which has been couched in the statute, my lord. Any other way, such exercise will be contrary to the statute and violative of not only to the statute, but at the same time violative of the fundamental right under Article 14.
Yes.
So all these cases, my lord, the penalty was imposed. I'll take your lordships to the penalty notices, my lord. At page 126.
One
126. Notice for deductions of penalty for quality control failure at Dankuni Point, DDR, Howrah. Whereas you have been selected as supplier of S30 sugar to these corporations by tender number so-and-so, and to this effect you have signed an agreement with so-and-so. Whereas clause 3 quality assurance clause of the said agreement clearly states that further in the event of any of the sugar sample out of built up stock in any godown found substandard, on testing in addition to replacement of substandard stock, penalty shall be imposed to the extent of sugar stock of the particular lot and or batch in the following manner. First time failure of sample substandard, 10% of cost of sugar stock. Whereas it is seen that the sugar supplied by you at Dankuni godown amounting 28670 quintals has failed to conform to the specification of S30 sugar as per IS. On inspection by the Quality Control Director of Food Supplies Department, Government of West Bengal, on dated 12th October 2018. Now, according to the agreement, clause referred to above, an amount of rupees 11,81,271.33 rupees only has been calculated as penalty on account of quality non-conformation liable to be deducted from the bill submitted by you for DDR Howrah district. You are hereby informed the matter and also directed to state in writing within 7 days if you have anything to say in contrary to the above. If no communications is received within 7 days from the issuance of this letter, after deductions of the penalty amount, bill in questions will be released. Then next, my lord, relating to Dankuni Point at page 15 January 2019. Notice for deductions of penalty for quality control failure at Dankuni Point. Then same, my lord, the recital of the same clause. Now, according to the agreement clause referred to above, amount rupees 1 crore has been calculated as penalty on amount of quality non-conformation liable to be deducted from the bill submitted by your DC Howrah district. Then, my lord, next.
Why two amount was calculated like?
Because this was calculated, my lord, because the calculations, my lord, the formula has been disclosed, my lord, in the tender document.
Okay.
That, my lord, the price, my lord, per my lord, metric ton is 3,899. into Milord the entire quantity by 10 Milord. So therefore, Milord, this amount will come. So then Milord at page 128. Notice for deductions of huh? Oh, because this is two different point, Milord. Storing point. One is it is Milord, one is DC Howrah and one is DDR Howrah.
No, page 126, 127.
Yes.
Dankuni point both.
Dankuni point DDR Howrah.
It is also DD's.
Yes, and Dankuni point DC Howrah. So two different students.
DC Howrah is
Yes,
different store.
different students.
Okay, okay.
So yes, and the memo number also different, Milord. That the 452 and 453.
But
Then Milord at page 128.
Quintals, amount of quintals is the same.
Quintal same Milord. In the both the two Milord, that the quintals are same.
Yes.
Then Milord at page 128.
Yes.
Notice for deductions of penalty for quality control failure at Bardwan Point, DC Purvo Midnapur. Quality involved, that is Agorola sawmills, small rice mills, Janardhan Godown, Mitokali rice mill, Anjiri Bagan Bardwan, Sri Join Goin rice mill, Salkia. Total quantity, Milord, on the basis of the total quantity, 45,39,978, Milord, penalty was imposed, Milord. That, Milord, all this, Milord, in case of quality specifications, Milord, upon resampling, all the reports, Milord, all the specifications was found, all the sugar, Milord, was found within the specifications, Milord, as prescribed under the tender document. Then page 129. Notice for deduction of penalty for quality control failure at Darjeeling district, DC Darjeeling. The recital same clause amount 50 lakhs 11,487. Then next page 130. That is failure at Jalpaiguri Godown.
Yes.
Total amount 15 lakhs 1,496, Milord. Altogether 2 crores 22 lakhs, Milord. Then, Milord, the petitioner submitted a reply, Milord, to this penalty notice, Milord, at page 141. We are really shocked to have received the aforementioned caption notices regarding deduction of penalty amounting rupees 2 crores 28 lakhs 34,000 for quality control failure at Dankuni, Darjeeling, Jalpaiguri and Bardwan.
You are reading page?
Page 141.
140.
Annexed P17.
Yes.
A reply to the notice for impositions of penalty, Milord.
Yes.
This all the notice composite reply was given, Milord. At page 141, we are really shocked to have received the aforementioned caption notice regarding deduction of penalty amounting to rupees 2 crores 22 lakhs 34,232 for quality control failure at Dankuni, Darjeeling, Jalpaiguri and Bardwan after a lapse of more than 3 months approximately from the date of quality control failure and subsequent pass report of the same stock. As per the above mentioned quality control failure lab report, the only reason cited for the rejections of sugar stock was due to higher moisture in sample collected from built-up stock. Now, as per IS 5982 so and so standard, where it is clearly stated that for purpose of deciding whether a particular requirement of the standard is complied with, the final value observed or calculated expressing the result of test analysis shall be rounded or in accordance with IS 1960 rules of rounding of numerical values. The number of significant places retained in the rounded off value should be the same as that of the specified value in the standard. By the word telling later dated 4th October 2018, 11th October 2018, 12th October 2018, last not least 13th October 2008, where your good self were pleased by the concerns raised by us in the aforementioned letter and passed orders for resampling of the same sugar stock, as there was inherited doubt about the test result obtained in the quality control failure lab report, which may have occurred due to erroneous sampling or testing procedures. Most importantly, by our letter dated 13th October 2018, the three moistures reading in the same sugar sample having wide variation of 0.07 between the highest and lowest moisture reading is highly fictitious, and even NABL accredited lab report of the same quality and branded sugar was also shared with your good self. The test report of moisture was well within the stipulated specification mentioned in the tender. Letter dated 13th October 2018 is marked Annexure A. When all the sugar sample build-up stock subsequently passed by the Directorate of Inspections and Quality Control without any replacement of original built-up stock by the lab report dated 11th October 2018, 14th October 2018, and 31st October 2018, and 2nd November 2018, when the sampling and testing was done with some precautionary measure and allowed it fit and passed it for public distribution. This itself is self-satisfactory about the erroneous moisture reading in initial test report. Now, now it really fails to understand the acumen of any sound mind that how can a substandard consignment without any replacement, especially in commodities like sugar, which is highly hygroscopic in nature, no amount of worship measure as mentioned in our trailing letter dated so and so, last one dated so and so, can reduce the moisture content in sugar, especially in rainy weather where relativity humidity is more than 90%. And my lord, on the last occasions I submitted before your lordship, my lord, that the sugar, my lord, is always, my lord, hydrographic in nature, my lord. If you kept in, my lord, open in the air, my lord, it absorb water from the air, my lord, and it will become, my lord, moisted. So therefore, my lord, it wholly depends upon the connections of sample, my lord, and the testing by a national accredited laboratories, that is NABL, or the laboratory specified under the FSSI Act. In a reply to the queries raised under the Right to Information Act, they categorically stated that was done by their own. Their laboratory is not calibrated, and this is maintained by their own people. And even the standard is not under the FSSI or Bureau of Indian Standard. It is of their own standard. So this is absolutely violative of the provisions of the standard document in two ways. So the whole, my lord, that the penalty is bad, my lord, on three counts. First, my lord, the whole exercise is arbitrary and unreasonable. Because in one case, my lord, that though higher grade of sugar, my lord, was supplied as per the tender document, still, my lord, I was, my lord, issued a show cause, my lord. And, my lord, I resampled and it was found, and it was reported in the test certificate that it is higher grade. Then I was exonerated. So the way how they have acted, then issues penalty 1 day, not even less than 1 day. 12th October penalty show cause was issued. I was directed to 13th reply. So
what happened? You have replied the.
I have replied this notice, my lord, but my lord, that was rejected. Penalty was imposed, my lord. That was challenged before your lordship, my lord. Then, my lord, on the next day, my lord, I'll take your lordship's, my lord, to the legal positions, and the, my lord, reply given by them to the queries raised under the Right to Information Act, my lord, and the relevant laws, my lord, because it has got two counts, my lord. One, my lord, penalty for quality failure, and second penalty, my lord, that is a less amount here, 2.22 crores, and that is 8 lakhs only for not building up stock, my lord, within time, my lord. So that I will show, my lord, that there was sufficient stock, my lord, from their own register, it would be apparent, my lord. So this is the case, my lord. Okay. So next day, my lord, I will place, my lord, all other aspects, my lord. as I have just touched upon, my lord. I'll show you from the document.
Next Wednesday,
And next one. Next one.
please take down. Argument on behalf of the petitioner heard in part. Let the matter fixed on 4th of December at 2 p.m.
Yes, I'm grateful to you.
Towel and hand towel. এটা নিতে হবে। Running nose. এটা রাখ। Yes, next.
Oh, so I was under the impression that today is 3:30, isn't it?
No, not
No, no,
3:30.
then I can, may I continue? Otherwise.
Yes, you can conclude. I think you are.
Yes, maybe that would be, because I was under the impression that.
No,
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 because
I think you are already
the
called for
Sahara told
another
me.
court.
Yes.
That's why I'm allowed you to go.
Yes. Right.
Otherwise, we can continue. No issue.
Yes, my lord.
You are running very smoothly, very well.
Yes. Then, my lord, for my lord, for what I have stated, I have, my lord, put it in a table, my lord, for your lordships, my lord, quick appreciations, my lord. I'd invite your lordship's attentions, my lord, at page 49, annexure A to my affidavit in reply.
Page 49.
49. A table has been, my lord, given. All what I have stated, my lord, that I have put in a table, my lord, for your lordship's quick appreciations.
Okay.
Name of districts: Howrah, Bardwan, Darjeeling, Jalpaiguri. District godowns, all the names of the godowns, party names, penalty amounts, then quality, quantity, date of sampling, reason for failure, moisture content, resampling, moisture, resample lab test, remark. So what I have placed before your lordship from all the documents, my lord, that I have put it in a table, my lord, so that your lordships quickly appreciated the whole position, my lord. Then, my lord, I will take your lordship, my lord, to page 279. That the applications filed by the writ petition seeking for certain information under the Right to Information Act at page 279 of the writ petition.
Yes.
Subject: date 25th June 2019, top of the application. 25th June 2019.
179?
Not 279.
27. Sorry. Application seeking information.
Yes.
RTI.
That top of the application, date 25th June 2019.
Yes.
Then, my lord, particulars of informations required. Paragraph 3.
Yes.
Xerox copies of all note sheet pertaining to the issuing penalty notice from your office dated so and so, reference letter number so and so. 2. Inform if standard procedure were followed while deducting penalty.
Yes.
2. Inform of standard procedure were followed while deducting penalty, and if chances to the supplier and if chances to the supplier was given for retesting of failed samples with external FSSAI approved lab, National Accredited Board for Testing and Calibration Laboratories. 3. Information regarding why WBSCC Limited had not made arrangement for retesting of sugar with external independent lab, even after several requests made by the supplier subject to clause A under testing of sugar on page 8 of the tender notice number so and so. 4. Inform if the lab from which sugar supplied to the corporation limited under tender number so and so was tested had any certificate of NABL or under the Bureau of Indian Standard Act on the date of testing or testing or till date whichever earlier. Then 1. This is the broad queries. Then 1. Inform if yes, then provide the certification photocopy. Then clause 2. Inform if the lab requirement were duly lab equipment were duly calibrated of Department of Inspection and Quality Control. Yes or no? If yes, then provide calibration certificate. Inform if no BIC or NABL certificate or authorizations is obtained for the aforementioned lab, why action should not be taken against WBSC Limited and Department of Inspections and Quality Control, all others involved, giving IS conforming certificate for sugar without being authorized to give under BIS Act. Then, my lord, I'll take you, lordship, my lord, to paragraph 13, my lord, at next page 280. All we are not reading because they have not replied all those queries, my lord. Then to 280, paragraph 13, 3, my lord, 281, my lord. Roman 3. Information regarding if WBSC Limited has FSSAI license. Yes or no? If yes, then please provide photocopy. Then I'll take your lordship to the reply what was given by the corporation. Question under point number 4, 1, 2, 3 and 13, 1 and 2 of the said application. 4, 1. What was the queries, my lord? Page 277.
Answers.
Answer.
Okay.
Yes. 4. Inform the lab from which sugar supplied the question, my lord.
Yes.
Inform if the lab from which sugar supplied to WBCS Limited under WBSCS Limited under NIT number so and so was tested, had any certification of NABL or under the Bureau of Indian Standard Act of the Directorate of Testing or till date, whichever earlier. If yes, then provide the certification photocopy.
Yes.
No. Answer is no. Then, my lord, 4.2. For 2 question, inform if the laboratory equipment were duly calibrated of Department of Inspections and Quality Control. Yes or no? If yes, then provide calibration certificate. 2. No. But the service engineer frequently visit in our laboratory and checking working conditions of the machine in use. So it is neither duly calibrated, my lord, nor, my lord, as specified under the FSI. Then, my lord, 3rd, information if no BIS or NABL certificate, National Accredited Laboratory, National Accreditations Board Laboratories certificate or authorizations is obtained for the aforementioned lab, why action should not be taken against WBSC Limited and Department of Inspections and Quality Control or other involved, giving IS conforming certificate of sugar without being authorized to give under BIS Act. Then answer 4.3. We are not issuing any certificate by using NABL logo. We are issuing report of sugar analysis and provide test result with mentioning remarks whether it is conforming to the specification standard set by WBSCS Limited. Neither BIS nor FISS, my lord, Food Standard Security Act, of their own specification. Then, once again, my lord, I will stop for a moment. I will take you, my lord, to the tender requirement at page 69.
Yes.
Yes. Quality assurance. The bidder shall have to ensure the quality of sugar supplied in 50 kilogram bags which strictly conforms to the ISS specification and FSSAI standard as per specification mentioned in schedule. But they are saying that this is their own standard. This is utter violations of the Food Standard Security Act, my lord. I will take your lordship to the relevant provisions, my lord. What was the requirement of the statute and what was violated by them. Then, my lord, paragraph 13, then the reply to 13.1. 13.1. Why the supplier, Mrs. Bengal Agency concern, were not addressed regarding their concern letter dated 13th October 2018 and etc. That is not most important. Then, my lord, the 13.3. Information regarding if WBSC Limited has FSSAI license, yes or no. If yes, then please provide photocopy.
13.3.
13.3. Then reply 13.2. Yes, 13.3. 13.3. My lord, the Directorate of INOC analyzed the sugar sample at page 277. The Directorate of INQC analyzed the sugar sample as per the tender specification set up by WBSCS Limited of sugar, where the limit for moisture is maximum 10%. So specifications set by themselves, not specifications set as required, my lord, under the Food Safety Standard Act or Bureau of Indian Standard Act.
No, in tender document, page 69, the first time failure of 10%. What is the specification? 10% moisture.
10% moisture.
It was in the tender document.
Yes, my lord.
Tender document says about the FSSAI standard.
Yes. Schedule 2 as page 64.
64.
Schedule 2. Your lordship has got it at page 64. Specification of sugar.
The top right hand side.
Schedule to right hand side. In the middle.
Specification of sugar.
Yes. Grades. The grade of sugar to be supplied should be S30 or higher variety as would be intended by the government. Description. The material should be crystalline, white, odorless and free from dirt, iron fillings and other extraneous matter. The required quantity should be manufactured, packed, stored and distributed under hygienic condition as per norms of Bureau of Indian Standard.
Yes.
Then, my lord, again I will take your lordship to
then a list is there, less of dyeing present by mass,
10%.
maximum 0.10.
So, my distributed submissions in 2 ways, my lord. So, my lord, first, my lord, it was found, my lord, excess, my lord. Failure of, my lord, specific standard, my lord. It was retested, resampling, and it was found within 0.10. And it is my submissions also, even this 0.10 is also not required as required under the statute, my lord. Statute says 0.5. So, even if it is exceeded, then well within the parameter. Then, if there is a, my lord, I submitted before your lordship, my lord, that if there is a my lord, if something, my lord, is required under the act, my lord, and required under the contract, my lord, then act should prevail over the contract, my lord. So, because, my lord, contract cannot override the statute, my lord.
Yes.
So, in any event, after resampling, we are covered by their own specification, even if it is contrary to act.
Who done the resampling first? The same authority.
Same authority.
Okay.
By the same authority.
Not the out
Not the other
independent
authority.
authority like
Other
that.
authority. So whole things is absolutely whimsical. Then, my lord. So then in two ways, my lord. Because first, my lord, because why this was done, my lord? Because it is our respectful submissions, my lord, that the laboratory, my lord, which has tested, my lord, might be that was not the proper. But second time when this was tested, my lord, all precautions was taken, my lord. Particularly collections of sample, my lord.
Collection of sample was
Sample.
not done properly.
Yes, my lord. That is most important. And how it will be done, my lord, that was prescribed, my lord, not only collection of sample and testing also. Because the tested in a laboratory, it must be either NABL or, my lord, any laboratory notified under the Act, my lord. But they have done by their own. And they don't have any license under the FSSI, they have admitted. Arshi. And then quality assurance clause says that the standard must be either FSSI or Bureau of Indian Standard.
Yes.
But they have admitted that they have set the standard of their own by the corporation. So it is corporation standard, not the BSI or FSSI. And my lord, in the tender, it was provided that the standard will be followed as per Bureau of Indian Standard or FSSI. And this is their subsequent, my lord, subsequent stand, my lord, that this was done by themselves.
By their own standard.
By their own standard. Okay. Then, my lord, সেটা তো পড়ে যাচ্ছি দেন মিলট এটা দাও তো এখানে অ্যাক্টের কপিটা আছে I'll take you মিলট to the Food Standards Act মিলট মিলট section 43
Yes.
Yes, my lord. Recognition and accreditations laboratories, research institutes, and referral food laboratory. The food authority may notify food laboratories and research institutions accredited by National Accreditation Board for testing and calibration laboratories or any other accreditation agency for the purpose of carrying out analysis of sample by the food analysis under this Act. The food authority shall establish or recognize by notification one or more referral food laboratory or laboratories to carry out the functions entrusted to the referral food laboratory by this Act or any rules under regulations made thereunder. It was, these questions were put to the authorities whether, my lord, they are, my lord, under the license of the, under the Food Safety and Standards Act, my lord, they simply answered no. Then the food authority may give regulations specifying the functions of food laboratory and referred food laboratory and the local area of areas within which such functions may be carried out, the procedure for submissions of the said laboratory of samples of articles of food for analysis or test, the form of the laboratory's report thereon, and the fees payable in respect of such reports, and such other matter as may be necessary or expedient to enable the said laboratory to carry out its function effectively. So this is the requirement of the laboratory, my lord.
The regulation has to be specified.
Yes, my lord. Then, my lord, I'll take your lordship, my lord, to the food safety standard rules, my lord, because copy of the rules has not been given.
Okay, you mentioned the rule. I will note down.
Yes.
Thereafter I will
Then Acha, acha. My lord,
You mentioned
the
the rule,
Food Safety and Standard Rules 2011.
FSS rule.
Yes. Definition clause 1.2.
1.2.
2. Clause 8. Notified laboratory means any of the laboratories notified by the Food Authority under subsection 1 and 2 of section 43 of the Act. So what I have placed before your lordship sections, that is the notified laboratory, my lord. And all the food articles should be tested by this notified laboratory, but none else. Referral laboratory means, because under the Act there are two laboratories.
Yes.
Notified or referral. Referral laboratory means any of the laboratory established and or recognized by the Food Authority by notification under subsection 12, section 43 of the Act. So this is the requirement of the laboratories. Then, my lord, I'll take your lordship, my lord, to no. To rule 2.1.4, food analyst.
Yes.
Yes. Qualification. A person shall not be qualified for appointment as food analyst under the Acts unless so and so holds a master degree in chemistry or biochemistry or microbiology, dairy chemistry or food technology, food and nutrition, or holds Bachelor of Technology in dairy and a royal or holds degree in veterinary science from a university established in India by law, or is an associate of the institution of chemist by examination of the section of food analysis conduct by the institution of chemist, or any other equivalent qualification recognized and notified by central government for such purpose, and has not less than 3 years experience in the analysis of food. So therefore, this is the prescribed qualifications along with 3 years experience of any, my lord, as a food analyst under the government.
These are the
Yes, my
specified
lord.
qualifications.
Yes, my lord. But, my lord, the persons who tested this, my lord, he also did not fulfill this qualifications requirement, my lord. That, my lord, I'll show, my lord, from the document, my lord, from the petition.
That person who tested.
Yes, my lord. That the food analyst
Food
of the department. কোথায় আছে? আরে ওই যে কোয়ালিফিকেশন গুলো যেগুলো পর দিল, 1 minute. তারপর কোয়ালিফিকেশন গুলো পর দেয়া আছে। Yeah. Yes. At page 108. Reply to the queries raised by the writ petitioners. SPI and Assistant Director in Inspection and Quality Control submitted a reply. With reference to the information sought under point 3.1 of your application under RTI Act 2005 dated 2nd July 2019, name of the person who functioned as chemist and signed the analytical report of sugar sample involving quantity 5931 quintals at Agorola small rice Bardwan dated 24th September 2008, name Shubhamoy De, designation supervisor, educational qualification BSc Agriculture, MSc Agriculture, Doctor of Philosophy Agriculture from Bidhan Chandra Krishi Vishwavidyalaya, photocopy of certificate is enclosed. So neither the required qualifications under the Act, nor he is having any experience as a Milord under any central notified laboratory for at least 3 years.
That is the requirement under the.
This is the requirement under the rules, Milord. So this was tested by a person who doesn't have any
master degree in agriculture.
Yes, Milord.
Agriculture is not listed in the.
Agriculture is not listed, Milord, as per the requirement.
Agriculture is not there.
No, Milord.
It's not a food analyst under the meaning of the.
Okay.
So his qualifications, Milord, didn't satisfy with the requirements as contained in this rules, Milord.
He's not a food.
And also, Milord, the experience. He must have at least 3 years experience under a central government laboratory or central government notified laboratory.
Experience cannot be ascertained here if
Yes,
you have
yes.
not asked for. You want only educational qualification.
Yes. So experience is also within the qualification. You ought to have mentioned. Because when the rule says that this is the qualifying requirement, so that is inclusive of experience. If somebody only having these qualifications will not satisfy with the requirements of the rules. So when rule says something in a certain manner, that has to be, Milord, in that manner alone. Milord.
Done with that manner of.
Yes, yes, yes.
Not in other.
So, Milord, so whole exercise, Milord, laboratory, Milord, is not as required under the Act. Persons who has tested not in accordance with the Milord, under the Act, Milord.
Qualifications of
Yes,
Act.
Milord. So having qualifications and the procedure which was prescribed in the Act and rules, Milord, that was not followed, Milord, while Milord drawing sample, Milord. So that might have the reason, Milord, for having this difference, Milord. So otherwise, why the same sugar was tested subsequently and found within the specification? And secondly, Milord, that assuming that even this report is taken to be correct, but this is also contrary to the requirements of the Act because it says 0.5. Thirdly, this sugar, Milord, was supplied, consumed. They have admitted in their own letter. There was no loss on the part of the government. Penalty would always attract because this is a punishment, is a penal measure. Something offense should be committed. No loss was suffered by the corporation. So all these irregularities, and right from the very start, because the so-called notice on the very first occasion, less day time was given to give reply. Even in the so-called notice, it was prejudged that you replace the substandard rice. You have given the decision without considering my reply to the so-called notice.
So what happened? You have directed to reply so-called within 13th. Within 13th.
Within 1 day.
Within 1 day.
We have given within 1 day.
You have given in the 1 day.
Within 1 day.
The resampling was done.
Yes.
And the all sugar quantity was distributed.
Oh, distributed.
Sugar samples passed.
All sugar sample
They were
passed.
failed earlier.
Passed.
What were failed earlier, that all passed. And this was consumed.
So
And because that
the
they are,
penalty was imposed.
then still penalty was imposed.
Okay.
Then, Milord, I will take your lordship, Milord. Yeah, boy, not first. Then rule 2.4.1 laid down for procedure for taking sample and manner of sending it for analysis. Detailed procedure, Milord. Particularly sub-rule 9. The sample will be packed and sealed in the manner prescribed hereunder. 1, 2, 3, 4, 5, 6, 7. That the details procedure has been laid down.
Yes.
Then, Milord, in exercise the power conferred, Milord, under section 92 clause E of subsection 2 of section 92, read with section 16, a rule was framed, my lord, namely the Food Safety and Standards, Food Product Standards and Food Additives Regulations 2011. This rule prescribed the specifications of the sugar, all standard of specifications relating to all food items, including sugar.
Rule of 2011.
2011. The Food Safety and Standards,
Food safety and
standards within bracket, Food Products Standards and Food Additives Regulations 2011.
Okay.
I will take your lordship, my lord, to regulation 2.8, sweetening agents including honey. 2.8.1, sugar.
Sugar.
Plantation white sugar, commonly known as sugar, means the crystallized product obtained from sugarcane or sugar beet. It shall be free from dirt, filth, iron fillings and added colors, coloring matters. Extraneous matter shall not exceed 0.1% by weight. It shall not conform to the following standards, namely moisture not more than 0.5% by weight. একটু দিয়ে দেখেন তো। হ্যাঁ, রুলটা দাঁড় বলে দিচ্ছি, বলে দিচ্ছি।
Moisture when heated at 150 degree, more or less 1 degree for 3 hours, not more than 0.5%.
So moisture contents, my lord, always, my lord, should be 0.5.
Okay.
Because this agreement was executed sometimes in 2000. No, this agreement was executed, my lord, letter of action 2018, my lord. So after coming into force of the Food Safety Standard Act and the regulations.
Okay.
Regulation came into force in 2011.
2011.
So therefore, my lord, that the entire penalty, my lord, I have challenged, my lord, on altogether 4 grounds, my lord.
Yes.
Yes. 2.8.1. Then before relying judgment, my lord, I will, on this point, my lord, I am summing up my, my lord, entire argument, my lord, that this penalty, my lord, was challenged, my lord, on 4 principal grounds, my lord. Number 1, my lord, that this penalty itself suffers from utter non-application of mind, my lord, to the relevant facts of the case, my lord.
Yes.
Number 2,
yes,
that the penalty was imposed on the ground of failure of quality specification, which was ultimately found to be within the specifications and allowed to be supplied and consumed by the end user. That is the members of Annodoy Anno Yojana family.
Yes.
Number 3, this penalty was imposed on the basis of the quality control report, which was not obtained as per requirement of the Food Standards Act.
Yes. Yes.
And fourthly, the authorities, they themselves have deviated their own standards specified in the tender notification. that the specification standard must be in conformity either to Bureau of Indian Standard or Food Security Standard, Food Security Standard Act. So on these basic grounds, my lord, apart from this mala fide, my lord, because I supplied, my lord, higher quality of sugar, still, my lord, I was issued show cause, stating that you have not fulfilled the requirement of the specifications as required under the tender clause. But the tender clause says is 30 odd higher variety. 31 is a higher variety.
Yes.
So still I was issued a show cause notice. This is utter non-application of mine, and whole actions was made in a capricious manner, whimsical manner. So this is absolutely contrary to the requirement of fair play in action. And that is why violative of Article 14. Because the executive authorities are required to act fairly, reasonably, and bona fide. That's the requirement of Article 14, starting from international airport authorities to Sri Lanka Vidyarthis, and latest judgment I will show before your lordship. Not all those judgment, only one judgment I will show, because here, my lord, the whole actions, my lord, spring out of a, my lord, the contractual obligations, my lord. So that judgment will show, even, my lord, government actions involved arbitrariness in the field of contract, my lord, that is liable to be interfered with in the jurisdiction and to be quashed. So everything is liable to be quashed. Now, my lord, I will, my lord, rely, my lord, two decisions before your lordship, my lord, that on the same, this is a, my lord, this is a well-settled law, my lord. It doesn't require, but still, my lord, for your lordship's
Yes, please.
appreciations, my lord. Western Jigoda. Western Jigoda. My lord, this is a case, my lord. This is a case, my lord. The case, my lord, the facts of the case is this, my lord, that the workman was appointed, my lord. My lord, this particular establishment where this particular workman attached, my lord, is governed under the Indian Standing Order, Standing Orders Act, my lord.
Okay.
Then, despite subsistence of the Standing Order Act, this establishment entered into a special agreement. Standing Order says that after expiry of 6 months, workmen should be given permanent status. But this special agreement says that such appointment should be given after 2 months. 2 months requirement. So now the questions, my lord, whether, my lord, this requirement of 2 months as contained in this particular document or the standing orders as required 6 months will be, my lord, will prevail, my lord.
Which will prevail?
Which will prevail, my lord. The Supreme Court came to a findings, my lord, at paragraph 11, my lord, 1974 3 SCC 330, paragraph 11. This special agreement at page 335.
Okay, got it.
This special agreement, in so far as it provides for additional 4 months of probationer in an act in contraventions of the standing order. We have already held that it plainly follows from section 4, 10 and 13(2) that the inconsistent part of the special agreement cannot prevail over the standing order as long as the standing order is in force. It is binding on the company as well as the workmen. To uphold the special agreement would mean giving a go-by to the Act's principle of three-party participation in the settlement of terms of employment. So we are of opinion that the inconsistent part of the special agreement is ineffective and unenforceable. So standing order will prevail. Then, my lord, another judgment, my lord, I am relying a division bench judgment, my lord, of this honorable court, my lord. At paragraph 50, reported in AIR 2001, Calcutta 102. Paragraph 50, my lord. This court, with great respect to the learned judge, cannot accept the aforesaid proposition. The proposition that a contract between the parties will prevail over an overriding statutory provisions is contrary to basic norms of jurisprudence. A statutory provision is the sovereign will of the legislature and the same binds everyone and certainly the parties who are coming under it unless the provisions is made subject to contract or the law is repealed or declared unconstitutional by a competent court. If the proposition laid down in Gonpath is followed, the same will lead to disastrous consequence. This held contrary. Any two individuals should be allowed to contract out of a statutory liability. It is well settled that there cannot be no contract which could defeat the provisions of any law. That's the ratio, my lord. That they cannot. A contract cannot defeat the statutory provision. So statutory provision says 0.5 and here they are put the set the standard 0.1. Now one can argue, my lord, that might have a scope that less than 1% they have stated. Less than 1, so they have not stated exceed 0.5, less than 1%. So questions is this, my lord, this prescribed parameters was fixed by the legislature, appreciating, my lord, all the characteristics of the sugar and the prevailing atmospheric conditions of the state, my lord, because humidity and all this. So that is why this standard was set. And by leaving aside that standard, at your own sweet will, if you put something else, my lord, that you cannot. That is a, my lord, absolutely arbitrary, my lord, that the, yes, my lord, executive discretions cannot be exercised over the statutory mandate, my lord. So this is,
they can argue that you being a party to the contract have entered into the contract with a specific
yes,
terms.
yes. So that is why then, my lord, I will go back to the very old judgment, my lord, that Kiran Singh's judgment, my lord, that defect of jurisdictions,
Yes.
my lord, cannot be cured by consent of the parties, my lord. Once, my lord, the jurisdictions is defective, my lord, it cannot be cured by the consent of the parties. So if the statute says this, it cannot be given go by. So that's exactly, my lord, that the language employed by our division bench, Justice Ashok Ganguly presided over, and my lord, Mr. Justice Punab Chattopadhyay, as his lordship then was, that they should get disastrous position. If two parties sitting together and, my lord, defy the mandate of the statute,
land, then
yes,
everything would be
yes, my lord. That can't, my lord. So, and this is also a settled law. There cannot be any stopple against statutory operation. So all these will come into play, my lord.
Yes.
So now, my lord, I will rely, my lord, another judgment, my lord, that if any, because the procedural aspects, collections of sample, testing of samples will have a very paramount considerations. Because in this case, my lord, though facts quite different, he has gone to the trial, but ultimately what ratio was laid down in this case, my lord, that if any sample, if it is drawing of sample, if it is, my lord, not in conformity to the rules, my lord, then that should be held to be declared bad, void. I invite your lordship's attention, my lord, to a decision reported a single bench, my lord, though, my lord, in the High Court of Rajasthan, my lord, reported in 1983 Supreme Court cases online Rajasthan 352. This has said many things, but straight way.
This is a criminal appeal.
Yes. Only the ratio I am just placing.
Okay.
Last page, my lord. He also admitted that if the samples are kept into different grades of glass, then there can be a difference in visual color. This being the position, there is no material to suggest that the standard sample kept by the NSI was in a bottle exactly similar to that which was supplied to the factory. Apart from it, when the expert himself admits that the polythene bag is not an absolute guarantee about dampness, there is strength in the argument advanced by the learned counsel for the respondents that the deterioration in color might be on account of sugar being kept in polythene bags for a long period prior to the visual comparison. That is from June 1573, the date of taking the sample up to December 573. The date of exhibit P4 or near about it. When the sample might have been compared by the chemist, there is also force in the argument of the learned counsel that when 40% variation is permitted in the grain size, variation in the color grade also is possible because of the atmospheric humidity and the sugar being highly to attract hygroscopic. Sugar has an inherent quality to attract moisture, and I therefore find force in the aforesaid arguments of the learned counsel for the respondent. The learned counsel for the respondent also advanced arguments regarding the company not being made and accused, as the learned magistrate has acquitted the respondent on the ground of not drawing and packing the sample in conformity with the prescribed rules and for the reason stated above. So, the rules, my lord, was not, the sample, my lord, were not obtained and tested as per the required rules, my lord. That is why, my lord, that, my lord, magistrate held in favor of that, my lord, appellate.
Yes.
So this is the ratio. The facts is completely different, but this is the, so the requirement of the rules is, my lord, paramount considerations, my lord. Because once, my lord, that the rules has set, my lord, because it deals with the all food articles, my lord. Because otherwise, if somebody puts a particular standard and somebody puts a different standard, then there will be a, my lord,
Anarchy.
absolutely anarchy, my lord. So that is why to put a limitations of the upon the executive power, my lord, this rules was framed, my lord. And my lord, in one case, देखिए ये तो it's a constitutional judgment. It's very old judgment. কপিটা কি করেছে? বই এনেছে গো। তো বইটা বার করে দিয়ে এলাম। সুখদেব সিং। এটা অন্য বই। ওই যেটা দেখো ওখানে কপি আছে। Milord, this is a, Milord, whole judgment is a constitutional bench judgment, Milord, and still hold the law. Reported in 1975, one Supreme Court cases 4-1, Milord. The words rule and regulations are used in an act to limit the power of the statutory authority. The powers of authority bodies are derived, controlled, and restricted by the statute which create them and the rules and regulations framed thereunder. Any action of such bodies in exercise of their power or in violation of the restrictions placed on their powers is ultra vires. The reason is that it goes to the root of the power of such corporations, and the declarations of nullity is the only relief that is granted to the aggrieved party. So, all the authorities, my lord, power and authorities derived, my lord, from the requirement of the statute, my lord. And because statute, my lord, put a restrictions on the limit of the power of the executive authorities. And any actions, if it is taken, my lord, contrary to such, my lord, I don't know.
Sukhdev Singh and others versus Bhatta Kamsar.
The constitutional bench judgment, very old judgment.
Yes.
Many aspects has been, my lord, dealt with, my lord, but I have placed, my lord, only for my beneficial part, my lord, of this judgment. And this law, my lord, still hold the field, my lord. এইবার এটা এমপি পাওয়ার এমপি পাওয়ার এই তো সুখদেব সিং
মানে আপনার এইটার মধ্যে
এমপি পাওয়ারটা বার এমপি পাওয়ারটা দাও
Yes. Give me the book.
Yes, my lord, copies are handing over.
Copies is good.
1975
এর মধ্যে আছে দাঁড়া 1 minute. MP Power Management Company Limited, Jabalpur versus Sky Power Southwest Solar India Private Limited, reported in 2023 two Supreme Court cases 703. Paragraph 82. Paragraph 75 first, my lord. At page 759.
Yes.
Yes. We would therefore sum up as to when an act is to be treated as arbitrary. The court must carefully attend to the facts and circumstances of the case. It should find out whether the impugned decision is based on any principle. If not, it may unerringly point to arbitrariness. If the act betrays caprice or the mere exhibition of the whims of the authority, it would sufficiently bear the insignia of arbitrariness. In this regard, supporting an order with a rationale which in the circumstances is found to be reasonable will go a long way to repeal a challenge to state action. No doubt, the reasons need not in every case be part of the order as such. If there is absence of good faith and the actions is actuated with an oblique motive, it could be characterized as being arbitrary. A total non-application mind without due regard to the rights of the parties and public interest may be a clear indicator of arbitrary action. A wholly unreasonable decision which is little different from a perverse decision under the Westnesbury doctrine would qualify as an arbitrary decision under Article 14. Ordinarily, visiting a party with the consequence of its breach under a contract may not be an arbitrary decision. So therefore, any actions even involves arbitrariness in the field of contract, then, my lord, it is, if it is contrary to that requirements, would be held to be arbitrary. Then, my lord, paragraph 81. Paragraph we have already concluded, your lordship has got it, paragraph 81. We have already
Paragraph 81.
we have already concluded that the power purchase agreement is not a statutory contract. However, that would not be the end of inquiry. Dr. A.M. Singhvi, learned senior counsel, would point out that the contract not being a statutory contract assumes relevance only for the purpose of deciding as to whether the court should delegate the writ application to alternate remedies. In other words, while the court would retain its discretion to entertain the petition or decline to do so in the facts of each case, there is no absolute taboo against the court granting relief. Even if the challenge to the termination of a contract is made in the case of a contract which is not statutory in nature, when the offending party is the state, in other words, the contention is that the law in this field has witnessed an evolution, and what is more, a revolution of sorts and a transformatory change with a growing realizations of the true ambit of Article 14 of the Constitution of India. This state, he points out, cannot play the Dr. Jekyll and Hyde game anymore. It is nature, its nature is cast into stone. Its character is inflexible. This is irrespective of the activity it indulges in. It will continue to be haunted by the mandate of Article 14 to act fairly. There has been a stunning expansions arising out of contract based undoubtedly on the facts of each case. It remains open. ঠিক আছে. Action in matters arising out of contract based undoubtedly on the facts of each case, it remains open to the court to refuse to reject a case involving state action on the basis that the action is partially arbitrary. The same thing was hold, my lord, in case of Sileka Biddartis. State action involves arbitrariness. My lord, writ jurisdiction would be invoked, and my lord was the order, my lord, on the ground of arbitrary action. Then paragraph 82.2. The principle laid down in Verily Development Authorities that in the case of a non-statutory contract, the rights are governed only by the terms of the contract and the decisions which are purported to be followed, including Radhakishan Aur, may not continue to hold good in the light of what has been laid down in ABL. My lord, ABL International, this is a, my lord, this a go, my lord, ahead further, my lord. And as followed in the recent judgment in Sudhir Kumar Singh, 82.3, the mere fact that relief is sought under a contract which is not statutory will not entitle the respondent state in a case by itself to ward off scrutiny of its action or inaction under the contract if the complaining party is able to establish that the action or inaction is partially arbitrary. It is not whether it is contractual or not. It is whether it is arbitrary or not. Action is arbitrary or not, irrespective of contractual or not. 82.4. An action will lie undoubtedly when the state purports to award any largesse, and undoubtedly this relates to the stage prior to the contract being entered. This scrutiny, no doubt, would be undertaken within the nature of the judicial review which has been declared in the decisions in Tata Cellular. Then 82.5. After the contract is entered into, there cannot be a variety, there can be a variety of circumstances which may provide a cause of action to a party to the contract with the state to seek relief by filing a writ petition. Then 82.10. The reach of Article 14 enables a writ court to deal with arbitrary state action even after a contract is entered into by the state. Here they might say that this is a contractual obligation.
Yes.
Because the contract was executed, you are bound by the terms of the contract. If any actions is there, this is contractual, not amenable.
Go to arbitration.
Yes, my lord. So that cannot say. This reach of article, this, my lord, the court's approach in dealing with the same would be guided by undoubtedly the overwhelming need to obviate arbitrary state action in cases where the writ remedy provides an executive effective and fair means of preventing miscarriage of justice arising from palpably unreasonable action by the state. Here, palpably unreasonable actions of the state, my lord, on various counts which I have canvassed before your lordship. Then, my lord, paragraph 82.12. In a case, the state is a party to the contract and a breach of a contract is alleged against the state, a civil action in the appropriate forum is undoubtedly maintainable. But this is not the end of the matter. Having regard to the positions of the state and its duty to act fairly and to eschew arbitrariness in all its actions, resort to the constitutional remedy on the cause of action that the action is arbitrary. If the action is arbitrary is permissible. However, it must be made clear that every case involving breach of contract by the states cannot be dressed up and disguised as a case of arbitrary state action, while the concept of arbitrary action or inaction cannot be cribbed or confined to any immutable mantra and must be laid bare with reference to the facts of each case. It cannot be a mere allegations of breach of contract that would suffice. What must be involved in the case aside, it is therefore that the liberty was given to the to push pressure and so. So ultimately, my lord, this decisions, my lord, that's held, my lord, that, my lord, any arbitrary actions, my lord, taken by the respondent authorities, my lord, even in the contractual matter, my lord, is liable to be struck down. And on the last, next day, my lord, that is, that involves a less quantity of penalty, that is 8 lakhs, my lords, for not building up of stock, my lord, in due time, my lord.
In this matter?
In this matter, my lord. That is another penalty clause, my lord.
Another writ petition?
Not in the same writ petitions, my lord. Only 2.22 crores for failure to conform to specific standard of sugar. And second is, my lord, for failure to build up stock within the time. So that is amounting to only penalties amounting to 8 lakhs.
Okay.
Here 2.22 crores. So,
you
major part I
challenge-
have already argued.
You challenge both the matter
Yes.
in the instant date petition. Okay.
Either 3 or 5 minutes because we may have a other matter on 4, but my junior cannot remember.
Something is there, right? If you could just comment back.
As your lordship will have told me.
Any.
Now, next week I have fixed several matters.
Oh.
That is the dispute. Can you come on 10th?
10th
না 10th হবে না তাহলে বুধবারই করি 4 তারিখই no on 4th this is all right my lord
4 is already booked.
oh already booked 5th my lord
5th I have some other determinations. Thursday.
then it will be deferred to
Yes.
so then 11th
10th by 11th
না 10th মণিপুর আছে
Thursday, Friday, I have some other determinations.
oh I see
That's why I cannot go to the group 8 matters.
then as your lordship is convenient only my lord 7 except 9 my lord because I'll not be here
Okay.
9th এ নেই আমরা
So you will continue.
Yes my lord on 10th
On 10th, can I fix on 3 p.m.?
Yes because I'll finish my argument
Okay, 3
Yes.
p.m. is sufficient, I
Yes.
think. Okay, please take down. Argument on behalf of the petitioner hardened part. Argument on behalf of the petitioner hardened part. Let the matter fixed on 10th of December at 3 p.m.
My lord,
Yes.
in the morning, my learned junior mentioned 2 items, extension of interim order, 23 and 70.
Yes.
Tomorrow will be expiring.
Okay, just a minute. Take it on.
Item 23 and 70.
Item number 23 and 7.
70.
70. Tomorrow, do you mention?
What you mentioned, you mentioned that one.
Tomorrow, do you mention?
Fine.
Yes.
হ্যাঁ আপনি বললাম আপনি বললেন আপনি দেখে দেবেন আমি সকালে মেনশন করে 23 আর 7